Distinguished speakers, colleagues, friends, my name is Thomas Wookty, and I am the Executive Secretary of the International Institute for Justice and the Rule of Law, or the IIJ as we are known. The IIJ is one of the 3 GCTF-inspired institutions, and we are proud to link this launch as a direct support to the implementation of Global Counterterrorism Forum Memorandum. I'd also like to express my sincere thanks to everyone for joining us today for this IIJ Juvenile Justice Initiative on the public launch of the IIJ Juvenile Justice Notes for Practitioners. To the eminent speakers we'll be hearing from, and to all of you who are participating virtually from around the world. I would also like to particularly thank the United States Department of State Bureau of Counterterrorism for its generous support for our juvenile justice work and for its sponsorship of this event. We've joined today to discuss a topic of utmost importance: how to respect unique rights and interests of children involved in terrorism cases, whether as witnesses, victims, or perpetrators, while still protecting the public safety and holding bad actors accountable. It is a true indication of the importance of juvenile justice that more than 400 practitioners from 59 countries on 4 continents have registered to participate in today's event. As noted in the beginning, the IIJ helped develop the Global Counterterrorism Forum Neuchâtel Memorandum on Juvenile Justice in the Counterterrorism Context, which sets out 13 good practices designed to guide criminal justice professionals on how to handle the children involved in terrorism cases. To promote those good practices, the IIJ, alongside Switzerland and the United States, developed and implemented a series of 5 regional workshops for practitioners from the Sahel, Middle East, North Africa, MENA, East Africa, Western Balkans, and Southeast Asia. The workshops conducted between October 2017 and November 2018 in Yaoundé, Cameroon, Valletta, Malta, and Bangkok, Thailand, welcomed participants from a total of 27 countries. The IIJ, assisted by experts, incorporated feedback from participants at these events into the first draft of the IIJ Juvenile Justice Notes for Practitioners, a set of 5 comprehensive practitioners' notes, one each tailored to the needs of the investigators, prosecutors, judges, defense counsel, and detention personnel. The following IIJ experts were involved in the drafting of the notes as follows: Ms. Irina Urumova and Mr. Paul Costello for the IIJ Notes for Investigators. Irina Urumova will speak during panel 3 tomorrow. I look forward to hearing you, Irina. Mr. Thomas Black for the IIJ's Notes for Prosecutors and Judges. He'll sit tomorrow in panel 4. Mr. Paul Gill and Ms. Julie McConnell for the IIJ Notes for Defense Counsel. We'll hear from Julie McConnell during panel 4 tomorrow. Mr. Zelalem Tafara is co-contributor to the IIJ Notes for Judges, and Mr. Michael Langelaire for the IIJ Notes for Detention Personnel. Michael Langelaire will speak during panel 3 tomorrow. Following the draft of the notes, we convened a Juvenile Justice Focus Group meeting to review and discuss the first draft and received suggestions for amendments. Then from July 2019 to September 2020, we organized 5 sectoral workshops on the draft notes dedicated to each sector to assess how the notes will be received and implemented, and to make them as relevant as possible for practitioners in the field. Meanwhile, we submitted the notes to peer review by practitioners and organizations with leading roles in the field of child justice. They include the Federal Department of Foreign Affairs of Switzerland, UNODC, Terre d'Hommes, UNICRI, Mr. Philippe René Nossa, magistrate from Cameroon, and Mrs. Elizabeth Gouan-Megemou, judge from Senegal. And last, Mr. Christian Bartholomew from the Council of Europe, who peer-reviewed in his own personal capacity. After incorporating comments and suggestions received from peer reviews, the IIJ finalized the IIJ Notes for Practitioners and is pleased to inaugurate them in today's event. What does that all mean? The IIJ has really dedicated a significant amount of its time and energy with our team to produce these juvenile justice notes because we believe so strongly in both the work of the Global Counterterrorism Forum, the Neuchâtel Memorandum, and implementing the GCTF documents, and last, making sure they are relevant to the people that we hope to work with in the future. These notes, the product of 3 years, expert meetings, peer review, and refinement, provide specific, timely, and practical guidance and examples to practitioners and policymakers on effectively handling terrorism matters involving children. More importantly, these 5 guides equip justice professionals to respect children's rights while balancing the ever-important need to protect society and hold back bad actors accountable, all in compliance with human rights and the rule of law. We're all thrilled that all of you share our interest in improving the treatment of children in terrorism cases and look forward to working with you in the days and months ahead to put these landmark guides into use in police stations, courtrooms, and detention facilities across the world. Following this launch today and tomorrow, the IIJ envisions developing and implementing a major rollout strategy which will include training regional practitioners and assisting them to incorporate critical concepts of the notes into judicial and police academies and developing tailored training modules that best suit the needs of countries. We have a busy agenda, so without further ado, I'd like to briefly introduce my good friend and colleague, Ambassador Stefan Husi. Ambassador Husi has been with the Foreign Ministry of Switzerland for nearly 35 years. He's a lawyer by training. He's also led important human rights and other issues within the Federal Department of Switzerland. He's a good friend of the IIJ. He also co-chairs the Criminal Justice and Rule of Law Working Group, which is one of the working groups of the Global Counterterrorism Forum, which most closely aligns with the work of the IIJ. It's really a great friend to introduce Ambassador Husi, who is a supporter of the IIJ, and I also am happy to call him a friend. Stefan, the floor is yours.
Thank you, Tom. Dear colleagues, ladies and gentlemen, greetings from Switzerland. It is a pleasure to be with you today and to open this two-day event together with the Executive Secretary of the IIJ, Thomas Wuchte. I would like to thank the IIJ for its long-standing engagement for juvenile justice and the protection of children in the context of counterterrorism, and for organizing this public launch of the practitioner's notes, gathering some of the most distinguished and dedicated experts on the topic. In the Global Counterterrorism Forum, the IIJ has been very active in developing the Neuchâtel Memorandum, as we have just heard from Tom, and which was adopted at the GCTF ministerial meeting in September 2016. For the GCTF, this was a landmark document, as for the first time children and their rights, interests and needs have been put at the center of counterterrorism deliberations and approach. The Neuchâtel Memorandum conveys 2 key messages. A child recruited and exploited by a terrorist group is a victim and needs to be protected. And second, juvenile justice is about an appropriate response tailored to the rights and needs of children and geared towards rehabilitation and reintegration. It does not exclude accountability for the wrong committed by the child. Switzerland has supported the IIJ in conducting awareness raising and training on the Neuchâtel Memorandum for investigators and prosecutors, judges, defense attorneys, and correction officers. We have also partnered with UNODC, who is doing a great job in developing guidance and capacities on justice for children in the context of counterterrorism. Last year, Switzerland, as co-chair of the GCTF Criminal Justice and Rule of Law Working Group, together with Nigeria, has developed the Memorandum on Criminal Justice Approaches to the linkages between terrorism and core international crimes, sexual and gender-based violence crimes, human trafficking, migrant smuggling, slavery, and crimes against children, which was endorsed at the GCTF ministerial meeting last October. Crimes against children in this memorandum refer to the recruitment or use of or trafficking in children by terrorist groups, which can take place within or outside armed conflict. The new memorandum aims to hold terrorists accountable for the full range of crimes they have committed, in particular the most serious ones. This is also in line with last year's 7th biennial review of the UN Global Counterterrorism Strategy, in which the General Assembly strongly condemned the systematic recruitment and use of children to perpetrate terrorist attacks, as well as the violations and abuses committed by terrorist groups against children, including killing and maiming, abduction and rape, and other forms of sexual violence, and noted that such violations and abuses may amount to war crimes and crimes against humanity. When Switzerland originally launched the initiative on juvenile justice in a city context 7 years ago, the phenomenon of foreign terrorist fighters who traveled from all over the world to Syria and Iraq was at its height. The call to join ISIL and the so-called caliphate was addressed not only to fighters, but to all kinds of supporters and their families. Today, thousands of children remain stranded in overcrowded camps and detention centers in northeast Syria, in dire conditions with limited access to food, medical care, education, and other basic services. The recent attack by ISIL against the prison in Hasakeh reminds us of the horrible situation and blatant violation of the fundamental rights of hundreds of male teenage prisoners. To conclude, I would like to express my hope that the IIJ juvenile justice notes for practitioners will contribute to raise awareness on such untenable situations and to promote the respect and protection of the rights of the child while countering terrorism in practical terms. I wish you all the best for this undertaking.
Thank you, Ambassador Hussey. Thank you, Stephen, for all of this great work and cooperation that we've had together with Switzerland, and for also spearheading the Neuchâtel Memorandum, which of course is one of the guiding principles that we've tried to implement together. We'll now be hearing from 3 distinguished speakers who will discuss their perspective on the ways counterterrorism measures are impacting the rights of children and the importance of applying child-centered juvenile justice standards as part of effective and sustainable counterterrorism strategies. I would first like to introduce Mr. Cornelius Williams, UNICEF's Global Director for Child Protection Program Group. He is responsible for the organization's strategic direction, policy, and programming in the field of child protection. A seasoned child protection professional with more than 30 years of global, regional, and country experience with UNICEF and Save the Children, Mr. Williams had led programs in both humanitarian and development settings across a wide range of child protection programming areas. Mr. Williams has served on several advisory boards and currently serves on the We Protect Global Alliance to End Child Sexual Exploitation Online and ID for Africa. He also sits on the steering committee of the Joint Program on Female Genital Mutilation and the Global Program to End Child Marriage and the UN Legal Identity Task Force. Mr. Williams holds a master's degree from the University of East Anglia, UK, specializing in international child welfare. He is a national of Sierra Leone, and he's based in New York. Mr. Williams, I give you the floor. It's a pleasure to see you today.
Thank you very much, actually, Thomas. And it's a pleasure to be here. I'd like to thank all the organizers and fellow panelists. This is what we in UNICEF would like to say. And I'm happy that I've been given this opportunity. I would also like to recognize the IIJ for developing the resources being launched today, which will serve as a critical guidance for justice personnel to better uphold child's rights in the context where counterterrorism measures are being implemented. Across the world, the counterterrorist architecture is expanding. Driving this expansion is the increasing number of counterterrorism Security Council resolutions and the expanding influence and presence of organizations designated as terrorists across the world. As the United Nations international partners engage with member states and provide them with advice and support to improve accountability for people who have committed terrorist acts, it's absolutely critical that child rights and child justice practitioners are central to this discussion. Unfortunately, in practice, counterterrorism measures are often implemented in ways that conflict with national and international standards for child protection and juvenile justice. And child rights and child justice actors are often absent from the conversation. As a result, rather than protect children, we have seen less protection and even a deterioration of their rights. We see children labeled as and treated as security threats and perpetrators rather than primarily as victims. And when they are labeled this way, the special protection contemplated by the Convention on the Rights of the Child often no longer seem to apply. Even when children have been exploited by these armed groups, we have seen states literally strip them of their fundamental rights. The Special Rapporteur on the Protection of Human Rights while countering terrorism has called this process unchilding, a process where the child is no longer viewed or treated as a child. Let me give a couple of examples of what we call this unchilding and what it constitutes of. There are well-documented cases of states amending laws that lead to indefinite detention of children with perceived ties to terrorist organizations and the expanded use of military codes even for children. As the last speaker said, we've seen it in northeastern Syria recently, a very dramatic reminder. Thousands of children detained arbitrarily, often for long periods without charge because of the acts, beliefs, acts or association of their parents or relatives, and the progressive broadening of counterterrorism legislation without safeguard and protection of children, ranging from one, expansion of criminal offenses related to terrorism, such as preparatory acts and forms of complicity, glorification of terrorism, and offenses that would otherwise not be criminal, and the broad way in which counterterrorism policies often define membership or association with terrorist organizations. People simply unlucky enough to live in conflict zone under the control of the group, including children and victims, who by the mere fact of being present are treated as associated with a terrorist organization. Particularly relevant to the IIJ notes for practitioners being launched today, UNICEF is alarmed by the failure of many state authorities to apply international juvenile justice and fair trial standards. We see this, for example, in national counterterrorism legislation that does not distinguish between children and adults. In reports of children being tortured as punishment or to extract intelligence, they are subjected to ill treatment. And in fact, there are reports of children being held in detention facilities treated as de facto adults without legal justification or due process, application of the best interest, and without any effective measures to redress this right violation. What we've seen is that children with actual or perceived ties to terrorist organizations remain at high risk of double victimization, first at the hands of the harm group, then again by their own government. I've seen it firsthand in my visit to Somalia when I was working in East Africa, and last year in my visit to Syria. For child rights and child justice advocates, there's never been a more critical time to be engaged, advocating for the application of international standards of child rights and juvenile justice to all categories of children, regardless of their age, affiliation, or situation. With this as a backdrop, UNICEF welcomes today's discussion on the launch of the IIJ Juvenile Justice Notes for Practitioners, and we can assure you that we will promote it. And it comes at a timely moment and spotlight concrete ways in which authorities can better uphold child's rights while also countering terrorism. So authorities and member states have no justification not to use these notes. Thank you very much.
Thank you, Mr. Williams. Again, on behalf of the IIJ, it was a real honor today to have UNICEF speak. We see that our practitioner notes have been taken into account many of the points that you've raised, and we do pledge that we will work and include you as we go forward with the training and implementation of this document. Again, thank you so much for joining us today. I would next like to introduce Mr. Irfan Saeed. Mr. Saeed is Acting Deputy Coordinator for the Terrorism Prevention and Detention of the U.S. Department of State Bureau of Counterterrorism. He manages offices that lead strategy and policy formulation for international terrorism prevention efforts, as well as international detention issues. He also serves as the Director of the Office of Countering Violent Extremism. Previously, Mr. Saeed served as the Director of the Community Engagement Office in the U.S. Embassy in Islamabad, Pakistan. Prior to joining the U.S. Department of State, he was a Senior Policy Advisor at the U.S. Department of Homeland Security Office for Civil Rights and Civil Liberties, where he developed and coordinated activities to counter violent extremism. Prior to joining Homeland Security, Mr. Said worked as a criminal prosecutor at the state and federal levels, and as Assistant United States Attorney, Department of Justice in the Eastern District of Louisiana, as well as New Orleans, Louisiana. He also serves as a resident legal advisor at U.S. embassies in Uzbekistan and Kyrgyzstan, two regions which I know quite well from my time in the OSCE. I'd like to give the floor to Irfan. He's a great colleague and supporter of the IIJ, and I'm also happy to call him a friend of the IIJ. Irfan, the floor is yours.
Thank you so much, Tom. Thanks for the kind introduction. Always a pleasure to see you and the great work that IIJ is doing. As you know, I'm always excited to participate in any IIJ event, and on behalf of the United States and the Counterterrorism Bureau at the State Department, we are grateful for the partnership with the IIJ and, of course, with Switzerland on this very important issue. We appreciate our partners at the UN Children's Fund, or UNICEF, and the UN Office on Drugs and Crime, UNODC, the Council of Europe, as well as our partners from Switzerland, Nigeria, Kenya, the Philippines, and Kuwait. And I'm so glad to share the virtual stage today with our friends from UNICEF and the Nigerian Federal Ministry of Justice, and I look forward to that presentation just a little bit later. So on behalf of the CT Bureau, we are proud to have partnered with the IIJ in this critical initiative aimed at addressing the challenges of juvenile justice as it relates to countering terrorism. We know this is not a new phenomenon. Many countries in different regions have recently experienced an increase in the recruitment, training, and use of youth by terrorist groups. And what we saw in the rise of ISIS showed us how intent terrorist recruiters are in reaching the youth by really leveraging the latest communication platforms and social media apps and talking in a language that youth really seem to understand and resonate with. The number of youth and children radicalized to violence, recruited, and involved in terrorism-related activities continues to be a rising trend in many regions around the globe. The criminal justice response to the involvement of youth in terrorism-related activities differs greatly from one national system to another. As countries, we sometimes struggle with addressing the criminal justice needs of juveniles while struggling to understand how they're being recruited, how they're being radicalized. And then as we try to counter that type of terrorism, we see a lot of difficulties in what we should and should not overlook and minimize. We must make sure that our partners around the world understand that these are not mutually exclusive. Maintaining juvenile justice standards is necessary for achieving effective and sustainable counterterrorism approaches. Put simply, we cannot treat juveniles the same way we treat adults. Through practical efforts like this, we help provide countries with the means to hold terrorists accountable, protect the rights of juveniles, and promote the rule of law. So turning to recruitment, as we know, terrorist groups are targeting youth locally, regionally, and globally through a myriad of methods. We have seen them target them in their own communities, then recruit children to join conflicts in other parts of the world. Some are not given a choice. Some are forcibly recruited or abducted. Some are enticed to join. Some have had parents or other very close family members, such as brothers or sisters, lead them into these groups, accompanying them as they travel to terrorist-controlled territories. So in trying to prevent youth recruitment, we have learned a few lessons, which we need to keep in mind. Foremost is the need to develop targeted prevention strategies that emphasize the creation of networks to support juveniles at risk, as noted in the Neuchâtel Memorandum that Tom talked about at the top. So engaging youth, their peer group, family members, and community figures directly is critical to a successful counterterrorism work across many contexts. That is, we must engage the youth, and we must engage the bystanders and influencers of that targeted youth. So in successful prevention work, at-risk youth, bystanders, and influencers are typically engaged as active participants and not just passive beneficiaries. Their peers and others need to be supported to be able to support them. Research shows that youth are most influenced by their peers, so positive peer mentoring is also often very important. We must also build and enhance community policing efforts, which is developing closer engagement and building trust between local communities and the police that take an oath to protect and serve them. We often discuss the life cycle to radicalization to violence. We must not forget about the back end of the life cycle of radicalization to violence. That is, youth who are subjected to or even participated in terrorism-related crimes. They need rehabilitation and reintegration support, and not just incarceration. We have found that youth need tailored, age-appropriate, often trauma-informed psychosocial support and counseling. This is the lesson we are learning from those children currently in displaced persons camps and detention facilities in Northeast Syria, something Ambassador Hussi mentioned at the top. And what we saw in Hasaka and the jailbreak in Hasaka just a few weeks ago shows us the importance of not only ensuring that we have the proper programs in place, but we also ensure that we don't just incarcerate. We actually have to play a role in getting children out of these detention facilities. So as these children re-enter their families, their communities, their societies, we need to treat them without stigma, one of the greatest impediments to mitigating recidivism. This necessitates an understanding on the part of investigators, prosecutors, defense attorneys, judges, and detention officials throughout the different phases of the criminal justice process, as well as integrating, as I noted, psychosocial support and providers. Those actors need to be equipped and supported to handle each juvenile differently and individually, employing the full range of alternatives as appropriate. All of this requires thoughtful planning, capacity, and the willingness to address our respective approaches. So today marks a significant step forward in providing countries with the means to address those needs. So thanks again for allowing me to say a few words off the top. Look forward to a very good conversation today and tomorrow. And again, look forward to some of the good questions coming after this. Thank you, Tom.
Thank you, Irfan, and thank you for the U.S. Department of State for its steadfast support as we brought this project together and to the launch today, which culminates in several years of work. Of course, we share your views on the importance of tying this all together, particularly the aspect of prevention, which we know is so vital as we move forward in working in our counterterrorism efforts. The next speaker I'm pleased to introduce is Mr. Aminu Kayode Alilu. He's Assistant Director, Public Prosecutions of the Federation of Nigeria. I also note with Ambassador Hussi at the beginning, Nigeria is also a co-lead of the Criminal Justice Rule of Law Working Group within the GCTF. Mr. Alilu heads the Terrorism Prosecution Unit of the Office of the Honorable Attorney General of the Federation of Nigeria, known as the Complex Casework Group of the Federal Ministry of Justice. In this position, he oversees the review and prosecution of thousands of terrorism cases. With over 15 years of experience in criminal prosecutions, Mr. Alilu is a seasoned Nigerian federal prosecutor. He has handled several high-profile criminal cases, including treasonable felonies, terrorism, smuggling, murder, armed robbery, money laundering, advanced fees fraud, and cybercrime. He is the first federal prosecutor in Nigeria to secure a conviction on the adulteration of baby teething drugs, which led to the deaths of over 200 children across Nigeria. As a result, he received a commendation from the Attorney General of the Federation and the Minister of Justice of Nigeria. Mr. Alilu, I am happy to give you the floor, and I look forward to your remarks.
Thank you so much, Mr. Thomas. I'm very glad to be here. It's a horrific truth that terrorism is now the single most dreaded menace tormenting our national tranquilities. Worse, our children are not left out in this global scourge. The UN estimates that Boko Haram, the predominant extreme group in Nigeria's northern region, has recruited more than 8,000 children since 2009, including children as young as 4 years old. In addition to being torn from their homes and communities, these children are exposed to extreme forms of violence, including insurgent attacks, physical abuse, and sexual slavery, and become desensitized to atrocity. Nigeria is among the growing list of countries that has begun to address the terrorist threat with domestic laws that prohibit and punish financing, joining, and supporting terrorist groups, as well as acts of terrorism consistent with international treaties and standards. Nigerian practitioners regularly invoke the Terrorism Prevention Act 2011 to combat the ungodly activities of members of Boko Haram, filing charges that include membership in a terrorist organization, financing of terrorist organizations, concealment of information, and rendering support to the terrorist group. Nigerian Child Rights Act also provides procedural protection for all children, including those associated with terrorist groups. Children are exempt from prosecution except for the most serious offenses, and even then can only be tried according to the child justice system and processes set out in the Act, which require that their best interests be protected. In addition, consistent with the best practices spelled out in the IIJ notes, the child's identity must remain confidential throughout the proceedings. This set of laws has worked well in many cases. I cite, for example, the case of a 17-year-old girl who was arrested in 2018 and charged with being a member of Boko Haram. When the evidence showed that her brother had sold her into marriage to a Boko Haram member when she was just 12, the charge was withdrawn, and at the request of the prosecutor, the court ordered she be de-radicalized and rehabilitated before being released to her parents. But substantial challenges remain. For example, children involved in terrorism offenses are often arrested by soldiers who then interrogate them in the field. Since the arrests often occur far from courthouses, impossible for the children to have legal representation. In addition, soldiers rarely attempt to determine the age of an arrested child, and children are thus detained with adults in common detention facilities, where they remain until UNICEF case workers take over their cases, liaise with their state governments, and if appropriate, arrange for their de-radicalization, rehabilitation, and reintegration into their society. Moreover, when children are prosecuted, the law granting exclusive jurisdiction over terrorism cases to the Federal High Court in Nigeria conflicts with the code granting the family court exclusive jurisdiction over minors, leaving children caught between the two. When Nigeria is undertaking affirmative efforts to address these gaps and better respect the unique and complex harms associated with children in terrorist groups, the Terrorism Prohibition and Prevention Bill of 2021, currently pending before the Nigerian legislature, will make it a crime to recruit children or other vulnerable persons into a terrorist group, use such persons to participate actively in hostilities or acts of terrorism, or to, in any manner, directly or indirectly, solicit the support of a child to a terrorist group. The bill prescribes an imprisonment term of 25 years for offenders. Nigeria has also recognized the need to establish dedicated detention facilities for children, specialized unit for children within the investigative and prosecuting agencies, Federal High Court, and social services, and a better method for identifying alternatives to detention. The IIJ practitioners' notes we dedicate today map out and highlight the present need for many of these practices and provide a framework for continuing our efforts to achieve them to better protect children caught in the violent wave of terrorism. Thank you, and I'm grateful for being given this opportunity to share the situation as we have in Nigeria, and I wish us a successful launch. Thank you.
Thank you, Mr. Alilu, and it's a pleasure for us to have you on the opening and launch today. I'd just like to let you know your connection was great. We heard you clear.
Thank you.
We're impressed with the work that you're doing in Nigeria. You're really at the level of really being involved in the Boko Haram, and the example you gave is quite highlighted for us about the challenges that this practitioner notes are able to address.
Thank you.
I'd now like to take the opportunity to ask a couple questions of our three speakers. I would just remind the audience today that there is no questions to be posed online today, but tomorrow at the follow-on day, you'll be able to ask questions directly of some of our speakers. So I have a set of questions for our three speakers. I'd like to go in order of the speakers, ask each of you a question, give you time to answer that question, and then I'll proceed to the next speaker. The first question I'd like to give to Mr. Williams. Mr. Williams, from the perspective of UNICEF, How should states and practitioners approach the issues surrounding children recruited by armed groups designated as terrorist organizations? What are the applicable legal frameworks and some of the key advocacy points that child justice practitioners should be aware of? Please feel free to take as much time as you need for the answer. Okay, we're right on schedule.
Thank you very much, actually. First of all, children who have been recruited and used should not be designated as terrorists, and they should be treated primarily as victims. Our second point is, from our work with member states, we know that to accomplish this, national legislation, policies, and practices, just like Mr. Liu said from Nigeria, right, must contain provisions that give children the status of victims. We should look at children as victims. The status in the law is important, irrespective of what role they played in this armed group. Provision relating to upholding children's rights, including their best interests, should be part of that. Second, children should never be handled to counterterrorism, security, or military frameworks. National counterterrorism and national security legislation should not include children. Instead, we should use the national legislation of the countries that relate to child protection, social welfare, victims of justice. And we've done this before in other armed conflicts before the advent of terrorism. The convention actually is the guiding document. You asked about the documents actually and frameworks. The Convention of the Right is the guiding document. And all the work relating to children. For children who are associated with these groups, the optional protocol, the Paris Principle and commitments, the Geneva Convention, the Beijing rules for the administration of juvenile justice are all important. And then we have Security Council Resolution 2427 that also highlights the situation of children who are associated with non-state actors, including groups designated as terrorists. Also, actually, it echoes good practice by calling on state to create SOPs for the rapid handover. Usually in our short term in the practitioner's world, we call it the handover protocol for children who have been encountered by security personnel during their military operation. And again, the other speaker actually from Nigeria articulated it very well, and we've worked with them in Nigeria on it. The last 2 points I'd like to highlight are well articulated in the IIJ notes for practitioners. One is that children under the age of criminal responsibility should not be detained. They should be handed over immediately. They should not be investigated. They should not be screened. They should not be persecuted. This bears repeating, as we have seen it happen very often. Second, actually, while children above the minimum age of criminal responsibility can be held accountable if there is evidence that they committed criminal act, remember, if there is evidence that they committed criminal act. However, this accountability mechanism must respect their rights and, as I said before, employ child-specific juvenile justice processes and safeguard with their best interests as a primary consideration. We believe also that you could do diversion of children. We've seen it done in all kinds of countries around the world, and where children were diverted from the custodial system. In UNICEF, we are now reimagining justice for children, and we're calling on justice and welfare actors to urgently work together to prevent and end detention of children. We have over several countries actually have released over 45,000 children during this COVID era. And we now believe there is evidence that you could safely release children and there will be no recidivism. So again, actually, as I would say, actually, while the international minimum standards is saying detention is a last resort, we can prevent detention. And as we have said, we often see the case of children accused of national offenses, acts, and they should be dealt with by the justice system. My final point is the IIJ note, Juvenile Justice Notes for Practitioner, rely on these and other key frameworks and principles. And in doing so, it's pulling together all these frameworks And it's now an important tool for state practitioners to understand and operationalize juvenile justice processes for these children. In effect, as I've said before, there is no excuse now for member states not to use these practices. We have best practice with these notes. Thank you.
Thank you, Mr. Williams. It was really a great overview of some very important points. Sometimes I always am fond of noting that sometimes the answers are even more interesting than some of the speeches we hear before. So that was really great, his thoughts on diversion and such. I would like to now go to Irfan. Irfan, what are the most significant concerns countries are facing when confronting the dilemma of juveniles who've joined terrorist groups or participated in terrorist crimes? Thank you. I look forward to your answer.
Yeah, thanks. That's a great question. And of course, Mr. Williams set the bar very high on providing a really good and succinct answer. So I'll try to do my best here. I like to note three things. I think the first thing we need to focus on, especially as it relates to those individuals that are in the Northeast Syria, especially those children that are in Northeast Syria, both in detention facilities, but also in displaced persons camps. It's this idea of repatriation, bringing them home in the first place. That for us, the United States, and I know some of our partners share this, is one of the biggest concerns that we have. We need to ensure that we're bringing the kids home. We need to ensure that we have the proper psychosocial support in place. We need to ensure that we have good rehabilitation and reintegration programs. And the research has shown us, above all, that these types of programs do not work in detention in detention facilities. You cannot be incarcerated and still be open to being rehabilitated. So the psychosocial support that these children need, and it's different from what adults need, it needs to be in a non-custodial setting. So that's the first thing. The second thing is this, traditional focus that law enforcement and the criminal justice sector has had in the past on incarceration. And I think it's been noted here. It's been noted in the notes for prosecutors, judges, defense attorneys that the IIJ has put out, that there needs to be alternatives to incarceration. We've learned that it's not helpful for children. It's not really helpful for a lot of offenders, but especially for children. And we continue to see, especially in the terrorism space, that prisons continue to play a radicalizing role. We know that prisons are one of the prime avenues for further radicalization to violence. We are talking about a literal captive audience of vulnerable youth listening to those recruiters who have the bona fides in place, so-called bona fides in place, to talk the talk and walk the walk and recruit those children that are literally in a custodial setting for them. So again, the first thing we need to do is not have this environment where children are literal captors to terrorist recruiters. And again, focus on alternatives to incarceration. And I think an important point there is some of the, again, action points that were noted in the IIJ Juvenile Justice Notes for Prosecutors, where it talks about specialized units. When I started my career in the district attorney's office, which are local prosecutors, our first step is to actually work in juvenile sections. We were trained on juvenile justice issues. We worked only with juvenile offenders, and we went to a separate court, a juvenile court. And it was that type of setting that allowed you to be a little bit more creative, both in the prosecution side, but also gave the ability of judges to, again, be a little bit more creative in how they could dole out sentencing. They could do, again, lots of alternatives to prosecution. They could do diversion programs. They could do community service. So all of these things, I think, were designed to set children along the right path and not just to serve as just incarceration and setting, I think, children back many, many years by locking them up. And the third thing I'll say in this answer is specialized prevention programs, something I talked about earlier. We need to have these specialized prevention programs focused on youth so that we can stop them from becoming terrorists in the first place. There's a lot of criminal justice overlap in prevention programs. Usually the first line of defense are the law enforcement officials, the criminal justice actors who have the information, who know what the radicalization narratives are, who the recruiters are, and who they're targeting. But the second line of defense, and it's a distant second, are those bystanders, are those parents, are those influencers of that targeted youth. And that needs to be reversed. The first line of defense needs to be the bystanders, the influencers, the parents. And the second line of defense needs to be law enforcement. Because when law enforcement gets involved, a criminal justice response is usually anticipated. So what we need to do is understand the role of some of these prevention programs, these specialized prevention programs. And one example I'll give is, working with things like misinformation, disinformation, how to identify deep fakes. These are tools that children absolutely need because they're online much more than adults are. And especially in this time of COVID, where we've seen increased levels of online coordination, being online and being exposed to much more misinformation, disinformation, and deep fakes. We as governments, we as practitioners, we need to do a better job of training the youth to understand what that misinformation, disinformation, and deep fakes. And it often starts with law enforcement, criminal justice actors who understand that. And so when I was working at Department of Homeland Security, and now some of the programs we're doing at State Department are focused on educating youth, getting into university settings, and providing those programs and initiatives to build that digital literacy and digital understanding that children need to have before they get online. So look forward to continuing a lot of those programs and initiatives globally. Thanks.
Thank you, Irfan, for that answer and for getting into some of the details about the importance of diversion and such. I would like to now give the last question to Mr. Alilu from Nigeria. What strategies does Nigeria use to reduce the number of children who are in pre-trial custody on suspicion of terrorism-related offenses? And what are the lessons learned in this regard? Mr. Alilu, over to you, please.
Thank you, Sir Thomas. And in the case of Nigeria, we all are aware of the fact that the children are always arrested, along with the those suspected who have committed acts of terrorism are usually arrested together with adults, and kept the same detention center. But what we do in Nigeria is the first thing we do is to ensure that the children are profiled. So with a view to ascertaining their ages, we know whether they are within the age of criminal responsibility. So the age will determine, because you do not tell the age of a child by his size. Someone could be as looking so little in terms of his physicality, and then you find out that he's an adult, maybe above 18 years under the Nigerian law. An 18-year-old child is already an adult in Nigeria. So we have to ascertain. The profiling helps us to ascertain the ages of the children. And then in the course of doing that, we also try to know how those children are indoctrinated into the sect. And because, it's unfortunate that the children we have are easily, based on their innocence and the fact that they are willing to explore, they are very inquisitive, they want to know. And so they take advantage of this vulnerability and then indoctrinate them into the sect's ideology. And then, so we usually find out how they got indoctrinated, and then the level of their involvement and participation. We interview them. In the course of the interview, we've seen a lot of the children who will tell us that, yes, I've killed like 10 people, 15 people, 20 people. I've participated in slaughtering this and doing that. So they tell us different atrocities they have committed. Because I must tell you that the Office of the Attorney General of the Federation of Nigeria is usually involved in the profiling and with the Nigerian military, and then with the support of UNODC. So a lot of questions are posed to these children, who are always very free, open to explain to us the circumstances leading to their indoctrination, how their parents were captured and they were indoctrinated and all that. So we get to know their level of involvement and participation. Then what we do is to immediately liaise with UNICEF as well as the state government. But most of the cases happen in Borno State, which is one of the core area where the Boko Haram insurgency is taking place in Nigeria right now. So the state government, together with UNICEF, receive the children and then take them back to their families. That's what we do. That is after the profiling, and we do not intend to keep them as long as we keep the adults. Under the Nigerian Terrorism Prevention Act 2011, as amended, a terrorist suspect is to be detained for a period of 90 days at first instance, and then another 90 days. That's making a total of 6 months. We do not allow the children to go through this lengthy detention period because we respect the Child Act forbids that the children are allowed to go through this. In fact, under the Nigerian Criminal Code Act, a child under the age of 7, no matter the offense has committed, is not even seen to have committed any offense at all. So, and even the child, any child below the age of 12 as well, is also not criminally responsible in Nigeria unless it is determined by evidence that he knew what he was doing as at the time the offense was committed, which is very difficult for prosecutors to prove anyway. And so the situation we have in Nigeria is that the rights of children to the best of the interest of the children have been well taken care of by ensuring that they do not stay too long with the adults. And then they are kept separately, even within the detention center, they are kept separately, provide immediately, and then we liaise with the UNICEF and state government for the purpose of returning them back to their families. So in the course of doing this, the lesson we learn from this is that these children are very, very easy targets for Boko Haram. So there's need for greater protection for children. Very easy targets for them. They are weak and vulnerable. In fact, the most vulnerable, more vulnerable than women. So, and then there is a need for us to sensitize our people at the grassroots of the dangers of joining the sect, because there are people who are made to believe that joining the Boko Haram sect has heavenly reward, apart from financial reward that they are going to get. And there is spiritual reward some of them believe in. So some parents are culpable and even encouraging their children to join the sect. So there's need for great sensitization within the grassroots to let them know the danger involved, that the society will suffer, the larger society will suffer, including the parents themselves, if they encourage their children to join the sect. And now another lesson we learned is that the government will have to invest more in the education of the children, because we realize that most of these children, if not all, are not attending any school. They pick them from the streets. They have no formal education. Of course, the agenda of Boko Haram as a terrorist group is that education itself is a sin. And they let them understand the fact that it's a sin against their God to be educated by way of the Westerners. And that is even the meaning of Boko Haram, because literally the Boko means book. Haram means forbidden. So learning is forbidden. That's what the set stands for. And so this is what they preach to the children, and this is what they let them understand. And because they've never had the opportunity of being schooled formally, so the first set of education, the will have called the unfortunate education, is the negative one that tells them that it is wrong for them to be educated in the Western way, and that the way of the sect is the way they should follow, the way of destruction, the way that sees government of the day as an enemy of the people. And so the way that by killing and maiming, they will find peace in this life and in hereafter. That the service, true service to their God is by killing their enemy. And everyone that does not follow their principle and ideology is an enemy, including the parents of these children. So government will have to now ensure that it invests more in the education of these people so that they will know the consequences and the implications of belonging to this set. So, and then the education, in investing in the education of the children, it should be financially free. It should be free education and compulsory for them. Like we have in Nigeria, there's already a program, Universal Basic Education, which makes education for the elementary education compulsory and mandatory. So there's a need to enforce that policy of government to ensure that every parent take his child to school so that they can learn the way
Thank
of
you,
law
Mr.
and not the way
Lilu.
of terrorism. Thank you.
Very, very powerful answer to a very tough question. I think we have about time for one, maybe two more questions. I'd like to go back then to Mr. Williams, and I'll see if we can get another question in after that, but if not, we'll wrap up this session. Again, I would just say all three answers were fantastic and very enlightening. So we have a few more minutes left before we go to the next session, so I'd like to go back to Mr. Williams with this question. From the perspective of UNICEF, could you speak about the importance of providing children recruited and used by armed groups designated as terrorist organizations with rehabilitation and reintegration assistance, highlighting lessons learned from the field, which sort of ties into the last discussion, the importance of providing children recruited and used with rehabilitation and reintegration. Mr. Williams, over to you.
Okay, thank you very much, actually. So really, actually, when working with government to support reintegration of children who've been associated with these groups, right, we use an approach that addresses the protection needs of those children. Each child in a manner that is survival-centered and community-based, and we consider the children's best interest. This approach comes from our UNICEF decades of experience. I don't know if people recall the civil war in Uganda. I mean, we've been in Uganda, we've been in Sri Lanka, South Sudan, Colombia. We've been recently in Somalia and Iraq, and even in my country, Sierra Leone, actually, I worked on this issue. We also actually have used this experience to support government in the reintegration of children who have been actually abducted or otherwise exploited by any armed group, even those designated as terrorists. And we've engaged with states who have repatriated and reintegrated children from Iraq, actually, and northeast Syria, and those who are stranded in conflict. Every child recruited and used by the armed groups definitely should have access to reintegration. And they should be supported, as I said, actually, in their transition into society and to play a meaningful role. If we don't do that, we will lose these children. And they are accepted, and they should be accepted by their families and communities and can maintain livelihoods, and dignity. It seems difficult, but we have done it. Rather than punishment, okay, and we should address the risk of vulnerabilities. Actually, again, like Mr. Coyote, actually, I hope I got your name right, was saying that leads to the association, and Said was also talking about. And then we should promote their recovery. Now, I've said the challenge is complex, but I've seen it firsthand, okay? For example, recently, actually, we collaborated with the government in Uzbekistan in reintegrating returning children from Iraq and Syria with links to family ties to ISIL. And let me highlight a couple of components that are important. Case management, targeted mental health, psychosocial support to address the violence, back to school, enrolling these children in school, helping them to catch up with their education, they need to get into school. And the school is a safe place, and the school is a healing place, and the school is a process that helps them to normalize. We have to find ways for caregivers and children to remain together and to maintain contact, including when the caregivers is facing persecution. Again, actually, Mr. Coyote, if I may use my example of Bono State, I was there, I think it was 2018 or 2019. And the Ministry of Women Affairs and Social Development was doing a fantastic job. And then working with children and the caregivers with link to Boko Haram, providing them with a comprehensive center-based service to support their recovery and reintegration. And after their release from the security forces, they continues to work with these women and children, providing the individual case management I spoke about, providing the mental health and psychosocial support I spoke about, the basic education, the life skills, the vocational training, right? The program also was designed to prepare these children to return back to their communities. What are they going to find in their communities? Where they're then connected to other actors for support. And we need to prepare the communities to receive these children. So to support. And then let me touch quickly on rehabilitation. On rehabilitation, we often offer similar service to integration, but this takes place in the context of the juvenile justice system and should be based on individual assessment. And the child should participate in this process. This may include approaches that encourage community-based alternatives to prison. As we said, the diversion, access to critical behavioral and mental health and psychosocial support. And in this case, we should focus on the trauma-informed care and disengagement from violence, if and when appropriate. Education again, life skills and pro-social attitudes and competencies, and approaches that promote close coordination with the child protection authorities for these children in complex situations or if they don't have parental care for their transition. With this holistic approach actually employed in the children's best interest, we find that the children, even those associated with armed groups and designated as terrorists, can recover and return to community life. Back to you, Thomas.
Thank you, Mr. Williams. We've run out of time. So Irfan and Mr. Lilu, I'm sorry we don't have time for another question, but I would like to thank all three of you for both your fantastic presentations as well as the great Q&A session that followed. Even for me personally, I'd have to say thank you. It was really an enlightening discussion. I also would like to thank my good friend and colleague, Ambassador Husi, for helping with the opening of this event. And to everybody that joined in and listened attentively to this opening for the launch of our practitioner notes. I do pledge to the three speakers now, as well as Ambassador Husi, we really are going to move forward with this practitioner's guide and move ourselves into the implementation phase now. With that, to keep us on schedule, I'd now like to move to three more distinguished speakers who will discuss issues related to accountability of children in a counterterrorism context and cross-border cooperation for child reintegration. I'm glad to pass the floor to my colleague, Ms. Gail Malone, the IIJ Director of Programs, to conduct the moderation of Panel 2, and I look forward to seeing all of you either virtually or in person at one of our future events. Gail, over to you.
Thank you so much, Tom. And thank you to the last three panelists for those passionate presentations based on field experience. They were really enlightening and we appreciate it. As Tom mentioned, I'm the Director of Programs here at the IIJ. It's my pleasure today to introduce our next three panelists who will discuss their perspectives on how to balance the unique needs of children against the importance of preserving public safety and holding children accountable for their roles in terrorism offenses. They will also discuss the importance of strengthening cross-border cooperation on issues related to the reintegration of children affected by terrorism. Our first speaker of this panel is Dr. Alexandra Martens, who heads the UNODC Global Program to End Violence Against Children at UN headquarters in Vienna, Austria. Dr. Martens' work involves developing international laws and policies and providing technical assistance on violence against children in the field of crime prevention and criminal justice to countries across the world. In recent years, she has focused on preventing and responding to serious forms of violence against children committed by organized criminal and armed groups, including those designated as terrorist groups. Dr. Martins has amassed 25 years of experience in the field of criminal law and children's rights through her work as a criminal lawyer in Brazil with the international NGO Save the Children, and since 2005 with UNODC. She graduated in law from the University of Sao Paulo, Brazil, and holds a postgraduate qualification in criminal procedural law and a PhD in criminal law from the University of Florence, Italy. Her various publications include the UNODC Handbook on Children Recruited and Exploited by Terrorist and Violent Extremist Groups, The Role of the Justice System, of which she is a co-author. Dr. Martins, it's our pleasure to turn the floor over to you for your intervention.
Thank you very much. Ladies and gentlemen, I'm delighted to represent UNODC on this important second panel of the public launch of the IIJ Juvenile Justice Notes for Practitioners, and I would like to thank IIJ for having associated us with this event. Let me start by talking a little bit about the phenomenon. Recent years have seen an increase in the volume of children who are recruited and exploited by terrorist groups. We cannot ignore this worrying trend, which may well be exacerbated by the ongoing COVID-19 pandemic. As we speak, children are being recruited, used, and exploited by these groups in a concerning variety of ways. This phenomenon can take many faces. We can think of a 17-year-old boy being recruited online, a 7-year-old girl being abused and exploited during times of conflict. And we can also think about a small toddler born of parents with foreign nationalities in a conflict zone under the control of a terrorist group. These are very different stories, but they all belong to children and illustrate the extent to which children have become a crucial resource for terrorist groups. Member states have reached out to UNODC for help in overcoming the challenges associated with this very complex phenomenon. A key barrier faced by most countries is the lack of a common approach. UNODC, thanks to its dual mandates in the areas of counterterrorism and child rights, is exceptionally well placed to bridge the gap between security and child protection by working with policymakers and professionals from the security, justice, and child protection sectors, and by addressing efforts to support countries in strengthening the justice system's capacity to prevent and respond to this serious form of violence against children. Let us turn to the treatment of children that are alleged to have committed terrorism-related offenses. Fundamental questions arise in relation to the legal status of these children. Are they victims? Are they alleged offenders? Questions also arise in relation to the laws, procedures, and authorities that they should be subject to. I would like to take this opportunity to thank the Global Counterterrorism Forum and IIJ, and all those involved in the development and launching of the Neuchâtel Memorandum, because this initiative provided for the first time a straightforward answer to these questions for professionals around the world. Children that are alleged to have committed terrorism-related offenses are primarily victims. And here I echo the words of Mr. Williams. But what does this mean in practice? UNODC has used its knowledge of challenges faced on the ground to develop an approach that is grounded in international law and which is detailed in the UNODC roadmap on the treatment of children associated with terrorist groups. The roadmap reaffirms the status of these children as primarily victims and tries to respond to the questions of what this means for practitioners, while recognizing that we cannot rely on a one-size-fits-all approach to addressing such a complex phenomenon. Allow me to highlight some overarching principles that are particularly relevant for this panel. First of all, why are these children victims? They are victims because the recruitment of children by terrorist groups is a serious form of violence against children. It is a crime defined by international law, and states are bound to criminalize it. Recruitment results in exploitation, and this has serious consequences for the well-being of children as well as for society at large. Secondly, how should these children be treated? It is important to clarify the fact that treating these children as primarily victims does not mean that impunity should prevail whenever children have been involved in terrorism-related offenses. The approach that we are promoting stresses the fact that children should not be prosecuted solely for association, but recognizes that decisions on whether children should be held accountable for crimes committed during their association with terrorist groups will depend on national legal frameworks. However, children who are alleged as or accused of or recognized as having infringed the penal law are always entitled to the full range of rights that are established in international law with regard to juvenile justice. There can be no exception or derogation to this entitlement on the basis of the nature of the offense committed. The treatment of these children should be aimed at their rehabilitation and reintegration and must therefore involve specialized and long-term support. And finally, most crucially, in the context of today's discussion, we need to overcome the perceived dichotomy between security interests and child rights or child protection. Issues of terrorism are too often framed as necessitating a choice between the effective protection of public safety and the full enforcement of child rights. However, and here I would like to stress, this presumption of fundamental conflict between child rights and security interests is both counterproductive and essentially inaccurate. Security interests and child rights are complementary objectives and need to be dealt with as such. Society will be safer from terrorism when children are better protected, and vice versa. In a rule of law system, human rights, child rights, and security cannot be achieved at each other's expense. They support each other, and together they are crucial to the building of long-lasting peace. Thank you very much for your attention.
Thank you so much, Dr. Martins, for that presentation. We're very hopeful that the lack of a common approach that you identified as one of the key barriers to successful handling of children will be solved dramatically with the publication of these notes, which will encourage a common approach. Our next speaker will be Ms. Jelena Jolik, Deputy Head of the Counterterrorism Division with the Council of Europe, where she has worked since 2015 on transnational crime matters. She is currently handling the counterterrorism standard-setting portfolio as co-secretary of the Council of Europe Committee on Counterterrorism and secretary to the Conference of Parties of the Convention on the Prevention of Terrorism and its additional protocol. Prior to her current engagement, she worked for years on economic crime matters, including financing of terrorism, both within the Council of Europe and elsewhere. She is a practicing lawyer with specialization in international law and holds an MSc in criminal justice policy.
Thank you very much. Good afternoon, ladies and gentlemen, distinguished panelists. It is my pleasure to address you today on behalf of the Council of Europe and its Committee on Counterterrorism on the occasion of the launch of the IIJ's Juvenile Justice Notes for Practitioners. Number of previous panelists have mentioned children are increasingly being instrumentalized in conflict as well as by terrorist organizations. And while this practice has been brought to the forefront by ISIL Daesh, it is unfortunately not the only one that should be of our concern. We at the Council of Europe have observed in the last couple of years this increase in the abuse of children by such organizations across the ideological spectrums. So therefore, it is natural that first justice sector responses are coming forward, including convictions of juveniles for terrorist offenses. And while as an organization, we largely support the need for accountability for criminal actions in all contexts, as a human rights organization, we always take the opportunity to highlight that the need for criminal consequences to be imposed in accordance with applicable human rights standards, and in this case, the guaranteed rights of the child. It is for that reason that the Council of Europe has adopted guidelines on child-friendly justice that should, among other things, direct member states on how to apply criminal legislation to children, even in cases of most horrific crimes such as terrorism. So, for example, the guidelines recommend that measures and sanctions applied to children always be constructive and represent individualized responses to the committed acts, bearing in mind the principle of proportionality, the child's age, physical and mental well-being and development, as well as the circumstances of the case. We are pleased to see these and other Council of Europe child-friendly justice guidelines well elaborated in the IIJ Juvenile Justice Notes for Practitioners, and we wish to congratulate the IIJ for this enormous effort that should inform and support all future initiatives of the justice sector officials in this domain. Our second area of focus in the context of children involved in terrorist organizations is the need for effective methods to disengage them from the milieu and reintegrate them fully back into societies. Irrespective of whether children who have been actively engaged in terrorist activity are prosecuted or not, it is critical that they are provided positive role modeling and other encouragement to understand the violence is not a means of resolving problems or disagreements, and be given a chance to settle back into their respective communities without being continuously stigmatized for their past affiliations. For this reason, in October last year, the Council of Europe has adopted a recommendation on measures aimed at protecting children against radicalization for the purposes of terrorism, which promotes the engagement of first-line practitioners such as teachers, professors, and youth workers in identifying and reacting to very first signals of radicalization by applying conflict management techniques and promoting critical thinking among children. And some of our member states have already started applying these approaches to preventing and addressing terrorism abuses of children. The recommendation itself envisages cross-border sharing of data and experiences among practitioners with a view towards establishing and supporting broad reintegration programs across jurisdictions. We strongly believe that complementing the efforts of specialized counterterrorism professionals with those of other practitioners who are in day-to-day contact with children increases the chances of successfully reintegrating the many who are affected by hatred and violence. So in anticipation of such future integration efforts, we look forward to seeing the juvenile justice notes put into practice as a way of ensuring that even within the criminal justice system, children continue being seen and treated as children and not as terrorists, and are given a chance for a fresh start while having a first-hand lesson in how individuals are treated in societies that observe the rule of law and human rights. I would like to thank you very much for giving me the floor.
Thank you, Ms. Jolik, for that impressive presentation. Particularly interested in the teams you talked about with frontline practitioners identifying the first signs of radicalization. We appreciate the Council of Europe's partnership and look forward to working with you in the coming weeks and months on the rollout of these manuals. Our next speaker will be Ms. Patricia Claire Oko, Executive Director of the Juvenile Justice and Welfare Council, a government agency focused on the implementation of juvenile justice in the Philippines. She is a lawyer by profession with extensive experience on children's issues. In addition, she's involved in drafting landmark laws in the Philippines related to child protection, including the Juvenile Justice and Welfare Act, the Special Protection of Children in Situations of Armed Conflict Act, and regulations and protocols related to those laws. Under her leadership, and as a result of her advocacy, the Philippines adopted in 2019 the GCTF Neuchatel Memorandum as a reference tool to inspire a new and comprehensive framework on how best to treat juveniles in cases involving terrorism and extreme violence. Ms. Oko, it's my pleasure to turn the floor over to you for your remarks.
Thank you, Gail. And it's my pleasure also to be part of the launching of the Juvenile Justice, IIJ Juvenile Justice Practitioners. And I would like to congratulate first the IIJ for the launching, as well as those people involved in the writing and the drafting of the practitioners' notes. So one of the major issues that we have for children alleged as, accused of, or recognized as having committed terrorism-related offenses is that we are confronted with a question on how to treat them in the justice system. How do we make children accountable while protecting their rights and addressing their needs, but at the same time, preserving the safety of the public? We should start from a perspective that in the context of counterterrorism measures, child protection and public safety are not opposing views, but must necessarily come hand in hand. Children's unique needs and rights can be respected and promoted even while we hold them accountable for the acts that they committed. If we fail to protect their rights and address their needs, we will also fail to keep our society safe from the threats of terrorism. Both the children and the community deserve a legal system that balances the protection of the society and the developmentally appropriate responses to children. We can do this by applying the juvenile justice standards when children go through the justice process. Right now, we do not have treaties on anti-terrorism that focus specifically on children recruited and exploited in terrorism and extreme violence. But we have guiding instruments, in particular the Neuchâtel Memorandum on Good Practices for Juvenile Justice in a Counterterrorism Context, and the corresponding IIJ Juvenile Justice Practitioners' Notes. They can be used as extensive guidance in bringing together these two dimensions of counterterrorism measure and juvenile justice administration in relation to these children who may have committed the terrorism-related offenses when they were recruited. In addition, social reintegration should also be a central aim of the juvenile justice, not only for the best interests of the child, but also because it has strong links to public safety. If the child can be reintegrated fully and can assume a constructive role in the community will be safe. Reintegration should include the child's health and psychosocial recovery, education, and later on, employment opportunities and return to the family if this is still possible, and of course, the community. The juvenile justice practitioners, particularly the investigators and the police, the defense counsel, the prosecutor, the judges, the detention personnel, they all have vital roles in ensuring that the social reintegration is ensured when deciding on what intervention will be provided for the child from the time that the child comes in contact with the justice system. As a country example in the Philippines, if a child requires accountability for a terrorism-related offense, we have a specialized juvenile justice and welfare system that was established under Republic Act 9344. The law provides the process where children could learn the consequences of their acts, develop empathy, and take action to repair the harm and have the opportunity to transform themselves. The main features of the specialized juvenile justice system also reflected the Neuchâtel Memorandum and the IIJ Practitioners' Notes Good Practices. For instance, the law established a diversion mechanism that can be used to address the offending behavior. And the law does not distinguish the crimes to be diverted, although it will consider the penalty attached to the crime. Diversion mechanism is available at all levels of the criminal justice system up to the trial in the courts. Detention in institution is the last resort and at the shortest possible time. Children are also not allowed to be placed in jail or even mixed with adults. The law requires the government to establish a specialized juvenile facility in case the child really need to be institutionalized. And of course, alternative measures to this detention should always be considered by the family courts, including even those who have committed serious offenses. And it does not distinguish whether that offense is related to terrorism or not. Community-based program for all children is preferred over institutional rehabilitation. and personnel dealing with juvenile justice are being trained, we train them for the proper and effective implementation of the law because that is a requirement. Moreover, the law applies to all children without distinction on the alleged offense. And we also do not allow the derogation of age when it comes to terrorism-related offenses. So our minimum age of criminal responsibility is absolute. So what is it like in practice? Of course, we are not perfect and we are still in work in progress, but hopefully because of the sharing of experiences and knowledge with other juvenile justice actors, like in this forum, we can also it can also assist us to effectively implement our juvenile justice system while addressing the threats of terrorism and preserving the safety of the country. Thank you very much.
Thank you so much, Ms. Oko, for that really interesting overview of the Philippines system, which is impressively child-centered and embodies a lot of the principles that we've tried to capture in the practitioner's notes. We'll be very interested in working with the Philippines in the next phases of this project to take advantage of your expertise in this area. I'd now like to turn us over to the question and answer period for this presentation by posing a question to each of the participants, and then as time permits, perhaps a second. I'd like to start with you, Dr. Martins, if I could. Is it possible to achieve both accountability and reintegration, and are those compatible objectives? A couple of our speakers addressed that very point, and it's a fascinating dynamic of holding them responsible, at the same time respecting rights and integrating. Interested in your views on that. Over to you.
Thank you very much, Ms. Malone, for the question. What I can say is that when reviewing requests for technical assistance, what we often observe is that many states still have the impression that public safety and child rights are incompatible and that they need to choose between them. In our view, it is possible to combine and achieve accountability and reintegration, but only if we think outside the box. If we move away from purely punitive justice approaches and recognize the importance for justice to be conducive to the rehabilitation and reintegration of children. We are often confronted in our daily work with misconceptions and narrow approaches to juvenile justice that do not serve the reintegration of children and their potential to take up a constructive role in society. We routinely hear that deprivation of liberty offers the only chance to, as we hear, teach these children who may have behavioral or related difficulties, to teach them the differences between the right and wrong, and that it is therefore the only possible judicial response. This is completely in contrast, not only with international law and the principle that deprivation of liberty should only be used as a measure of last resort for children, but also in contradiction with what we know works on the ground. Deprivation of liberty risks children's exposure to further forms of violence while disrupting education, family, and other important links to society. If deprivation of liberty is necessary to our vision of accountability, then we must conclude that accountability is indeed incompatible with reintegration. We are also faced with issues relating to deficit of resource and capacity. Resources are often held back from juvenile justice because it is perceived as a soft option that is less important than a real criminal justice system. So the consequences of these misconceptions are disastrous. We face situations where professionals are not appropriately trained, they do not see the system as having a future, and do not have the resources they need to implement innovative solutions. So juvenile justice systems that are not taken seriously can easily be discarded, especially when it comes to serious concerns such as children associated with terrorist groups. So the question is, how can we achieve both accountability and reintegration? This is what we ask ourselves. And we need to start by looking at our institutions and legal and policy frameworks, as well as at our priorities for resource allocation. Juvenile justice systems, as envisioned by the Convention on the Rights of the Child and other international legal instruments, are highly specialized and multidisciplinary systems in which the pursuit of public safety and the fulfillment of child rights go hand in hand. And this makes them the most appropriate forum for investigating and adjudicating of any case involving child alleged offenders, including those accused of terrorism-related offenses. So juvenile justice systems entail the ability to appropriately identify and investigate cases involving child alleged offenders through procedures designed to protect children from secondary victimization. These procedures have the additional benefit of supporting children to make reliable contributions to the justice process. And the example is child-sensitive interviewing techniques, which are not only in the best interest of the child, but also for achieving better evidence. So juvenile justice systems also are those that offer the possibility of foreseeing and applying a diverse array of responses to cases involving children as alleged offenders. And these include alternatives to prosecution, that is called diversion, detention, alternatives to detention, and rely on multidisciplinary teams. This would also be a system that does not deny children's wrongdoing, but that moves away from stigmatization and towards addressing the root causes of offending behavior. It would be a system that does not separate children from society, but rather supports them to claim their role as citizens, a system that does not punish, but rather repairs. And so we see that accountability and reintegration do go hand in hand. The juvenile justice approach is especially relevant to terrorism, which threatens the fabric of society and therefore requires responses aimed at creating cohesion. We need to continue working to strengthen juvenile justice systems and to see them as a crucial component of a systemic approach to child protection, which should not be sidelined. I am sure that the IIJ practitioners' notes are an excellent resource in this regard. Thank you.
Thank you very much, Dr. Martins. That was fascinating. I particularly was interested in your observation that juvenile justice systems are often under-resourced, when the irony is that if the children aren't reached, they may well become the next generation of terrorists. So there might even be an argument for greater resources to juvenile justice instead of less. I'd like to turn now to Jelena Jolik for question number 2. While some children associated with terrorist groups leave voluntarily and can thus receive rehabilitation services, others remain, whether due to indoctrination, fear, or lack of alternatives. How can practitioners reach these children without subjecting them to recrimination from the groups to which they belong? Ms. Jolik, over to you.
Thank you very much. I will again use this opportunity to promote the idea that has been integrated into the recommendation that I mentioned earlier, adopted by our Committee of Ministers in the fall. Probably one aspect that is being frequently overlooked is looking at other practitioners in addressing terrorism risks, including having children affected by terrorist organization and abused by terrorist organization. We often, when we think about how we address terrorism, we think about specialized counterterrorism professionals, which usually include law enforcement officials, intelligence officials, security services, criminal justice authorities, and similar, but overlook in this particular situation those who come into contact more frequently with individuals who might be targeted by terrorist organizations. So the idea of our recommendation and the response to your question would be to consider involving in such situations individuals who come into contact with children who might be already targeted by terrorist organizations, or parts of terrorist organizations, are taking potentially part in activities and are not interested in voluntarily leaving, and try to influence the way that they see things. So our proposal with the recommendation was to use professionals who come into contact with children on a day-to-day basis to try to influence in a way the way that they think about the world and what is happening around them, and the way that they should respond to what they see is happening, whether it be discrimination, injustice, or other issues. This could be, as mentioned, professors, it could be youth workers, it could be sports center workers, anybody who is in contact with children. Another possible source of influence for those who are engaged with terrorist organizations and are not at the moment voluntarily inclined to leave, and that we've heard about during our December conference on roles of women and children in terrorism, are families. So interestingly enough, some of the research done in the Nordic countries as well as in Germany on returnees has identified families as a potential reason for leaving terrorist organization. And the organization Women Without Borders has particularly invested in the program of involving mothers, sisters, effectively women, reaching out to male family members and trying to disengage them from the terrorist milieu and returning them back to their societies. So this is another avenue that could be exploited in terms of getting in touch with those who are heavily influenced by terrorist organizations and might not at a particular time be inclined to leave voluntarily. There have been successes in this. So what we have heard from examples in both Afghanistan, Pakistan, and in other countries where Women Without Borders have worked, is that they have had success in this type of engagement, and it might be something that practitioners in different jurisdictions might want to consider as a way of proceeding forward in these situations.
Thanks very much. So basically, it sounds like what you're recommending is a vast network of family members and practitioners who can offer children the role modeling and positive examples that they are not receiving when they're involved in terrorist organizations. And it sounds like that starts at the family level and expands to the community and beyond. Thank you very much for that interesting answer. I'd like to then turn to Ms. Oko for a question, if I may. Ms. Oko, can a child be both a victim and a perpetrator of terrorism? And if so, what kind of services should that child be provided? Over to you.
Okay, so the answer is yes. And I am talking about our domestic legislation. We have a very clear position in our domestic laws related to the status of these children and their treatment, and also the process. In the Philippines, we have a law that recognizes, and I quote, that it is the right of a child who is recruited in armed groups to be treated primarily as the victims. And this law does not distinguish whether it is a terrorist or violent extremist group or an armed group that is not categorized as a terrorist group. And as a result, these children are generally not prosecuted. It is the last resort, and all the applicable interventions provided for the child victim should be availed. But of course, there are instances where even if they are recognized as victims, they can also be prosecuted. And we have the juvenile justice law to do that, our juvenile justice system, because it is very important for us to address the accountability. We are adults, we have an obligation to guide and discipline these children if they make mistakes and bring them to the right path. And we also have to consider how to repair the harm to the victims, who might also include children and, of course, the community. So what are some of the rights of these children? What are some of the interventions that the state is obliged to provide? The state must provide programs for their rescue, rehabilitation, and reintegration. The court is mandated to follow the principles of relating to the reparation in respect of them as child victims, including their restitution, compensation, and rehabilitation. Take into consideration the scope and extent of any damage that these children might have suffered, loss, or the injury, that they might have experienced, provide psychosocial support, health and nutrition, education, livelihood for families, and other basic or legal services as may be necessary. And also, regardless of the perceived association of these children to any of the sides, in case there are armed conflict that's happening, all of them shall be provided with all the available medical services, as well as psychosocial, legal, shelter, and educational response mechanism services. And of course, safe access to essential, adequate, and culturally appropriate food and nutrition, sanitation, basic health services, as well as medicines and vaccines and package for reproductive health. However, we must also ensure that our responses to them, in case they are prosecuted, it should be an exceptional case. It should be developmentally appropriate, and it addresses the needs of the child as a victim and as a person, as a whole, and on the whole as a person. We have to approach this with utmost care, and especially the juvenile justice practitioners, to really determine the extent of victimization of these children, and as much as possible, not quickly prosecute. And the way the investigation will be handled by these investigators and the police officers will greatly help the prosecution to decide if the child should be treated solely as a victim, or if the child needs to be prosecuted also for the acts committed. And of course, the defense has to make sure that the child is treated primarily as a victim. And this is reiterated in the IIJ juvenile justice practitioners. And lastly, if the child goes to trial, the judge, the family court judge, must ensure that the juvenile justice standard should apply, because it will ensure the child's rights are protected, promoted, and fulfilled, and their needs are met. And these practitioners, at least in my country, they are required to be trained in order to effectively apply both laws related to children in these situations. Thank you.
Thank you, Ms. Oko. That was very interesting. When you were detailing the number of services and professional assistance the children charged with terrorist acts were entitled to in the Philippines, it struck me that some of our listening participants might find that those are more services and types of assistance than children who do not commit terrorist acts are entitled to. And it sets up an interesting dichotomy when we're talking about stigmatization. Very interesting topics for future discussion as we roll out the practitioners' guides in the months to come. Since we have a little bit of time left, I'd like to go to a second series of questions to our panelists. Going back to you, Dr. Martins, if I may. What is the role of international actors, and particularly UNODC, in strengthening cooperation between countries on this important issue? Over to you.
Thank you, Ms. Molona, for giving me the opportunity to answer this question. I would start by saying that developing and implementing measures for the treatment of children associated with terrorist groups can be highly challenging. At the national level, it demands a coordinated response across all of different branches of government and justice institutions that have responsibility for child protection and safety. And as we know, these include law enforcement, justice, counterterrorism, child protection, education, and health. The association of children with terrorist groups is indeed a very complex phenomenon, which has risen to international attention in recent years, but it's not entirely new, as we know. We may find examples of effective responses, good practices, and important standards and norms at the regional and global level. And when addressing a complex challenge, such as this one, we need to recognize the importance of learning from each other. I think that this is crucial if we are to strengthen coordination and cooperation, and also to respond to this global threat in a coherent and consistent manner. And in this regard, I would like to, again, commend the IIJ for having provided a global forum for a broad range of justice professionals from different legal systems and backgrounds to learn from each other. The IIJ practitioners' notes demonstrate the benefits of coming together to exchange knowledge and share ideas, and to create an important resource for peers and policymakers. And while institutions such as IIJ play an important role in strengthening cooperation between countries on this important issue, I would like to talk a little bit more about the importance of international organizations in carrying out this work, including the United Nations and more specifically UNODC, which is the organization I have been working for the last 16 years and know the best. So as you all know, UNODC is an office which is part of the UN Secretariat, and it has supported member states in developing international laws and policies on new and emerging issues. So it is based on our new dual mandate on counterterrorism and child rights that we have been positioned. We have been actually very lucky and positioned to strengthen cooperation with other international actors in this area. And international organizations, including the United Nations, have indeed played a very, very active role when it comes to setting the agenda with respect to counterterrorism, and also have responsibility for supporting states when needed. The treatment of children associated with terrorist groups provides a particularly valuable example of member states' successful cooperation with international organizations. If we think 7 years ago, we had no specific guidance focusing on approaches to the issue of children and counterterrorism. And today we have a wide range of General Assembly and Security Council resolutions that address and provide guidance on this specific issue. And I believe this is the result of a successful cooperation between countries and of the support of international organizations. UNODC, as a member of the UN Secretariat, has the added value of being involved in the advancement of international laws and policies in this area, as well as in the provision of technical assistance to member states. We have intervened upon request. We listen to counterparts and support them to find responses to the national priorities that they have identified. And in this regard, and also in addition to the invaluable tools that are now available to professionals, such as the example of the IIJ practitioner's notes, UNODC has developed a number of publications that address the treatment of children recruited and exploited by terrorist groups, and is currently working to elaborate additional tools. I can anticipate that we are developing with the support of the government of Switzerland, a tool on individual assessments. We're going to develop a tool on psychosocial support and specifically on children deprived of liberty. And each publication is developed with the aim of responding to requests coming from practitioners in the field, adding to the array of tools they need to deal with the challenges that they face on a daily basis. So I would like to conclude my answer to this question by stressing once more the importance of strengthening cooperation among countries to enable them to adopt a common approach. I think that I really would like to stress the need of a common approach for tackling this phenomenon, such as the approach that is outlined in the UNODC roadmap, as I mentioned before. And I also would like to stress the invaluable, the incredible value that the IIJ practitioners' notes bring to countries in this regard. We believe that this common approach will entail recognition that juvenile justice is able to pursue both accountability and child protection objectives, and also to help bridge the gap between security and child rights. Thank you again.
Thank you so much, Dr. Bartens, for that thoughtful response. The IIJ is surely appreciative of our collaboration with UNODC and appreciate your enumeration of many of the fundamental documents that the UNODC and other international organizations have put together to lead practitioners in this important field, and very much hope that these practitioners' notes we're inaugurating today will become part of those foundational documents that guide practitioners in improving their handling of children in terrorism cases. So thank you again for that answer. Turning then back to Jelena Jolik for another question. Let's consider that a boy is prosecuted for involvement in a terrorist organization in a country other than his country of origin. The court determined he was a victim and ordered rehabilitation and reintegration at the end of the judicial procedure. after the boy successfully completes these programs in the country where he was arrested, what measures should authorities take to ensure that he's not prosecuted in his home country for the same offense? Over to you.
Thank you very much for this interesting scenario. And through it, again, we can a bit promote the Council of Europe standards in this particular field, but also standards that have been, I would say, universally accepted, namely the nebis in idem or double jeopardy. Effectively, as the majority of or all criminal justice practitioners know, once a person has been either acquitted or convicted with a final judgment for a specific offense, they cannot be retried for the same offense or under the same set of facts. And this should apply also to children, irrespective of which type of sanctions have been imposed. So whether the court has decided just to state rehabilitation, or instead of, for example, implementing more serious sanctions such as incarceration, which is, as mentioned by many of the previous speakers, not recommended in cases of children. So effectively, for all the countries who have signed the European Convention on Human Rights, this is through Protocol 7 of the Convention, a rule, and that applies across jurisdictions. The same principle is also contained in the Covenant on Civil and Political Rights of the United Nations. Although not specifically in a cross-border concept, I would say that it has largely been understood to also apply in cross-border situations, with the caveat, of course, of situations where we have facts or information that might change the scenario, in which cases the situations become, one would say, more complicated. Similar is to the situations where the proceedings have not been finalized with the judgments, but rather have been terminated without any final decision on guilt or innocence. In those cases, these rules do not apply, but taking into consideration the discussions that have been previously had and taking into consideration the juvenile notes for petitioners that were prepared by yourselves, it would be important for justice sector practitioners to consider the proceedings held in a different country and to consider the value or the damage of having proceedings again initiated in their respective jurisdictions, especially for the same set of facts. We are talking about very complex crimes here, but also very complex situations involving children, and putting children, as is known, again, through the same criminal justice process, would only lead to re-victimization. For that reason, it would be preferable, although not, of course, formally still a valid rule, to, even in cases where the proceedings have been terminated without a formal decision or guilt or innocence, to avoid going through the same proceedings in other jurisdictions.
Thank you. In other words, continuing to keep the child's best interests in mind throughout the decision-making process, which I think is one of the underlying principles of these practitioners' notes. And finally, in the time that remains, I'd like to pose a final question to our third panelist, Ms. Oko. Can you give us some concrete examples of successes in the Philippines on social reintegration, and perhaps a few lessons learned based on your experience? Over to you.
Okay, thank you. So we really want to ensure, at least in our country, that children can assume a constructive role in the society. So what we want to do is to establish mechanisms that will ensure the support with the end view of their successful re-entry. And we have established programs related to intervening to providing intensive intervention for these children who might be at risk or committing serious offenses, although it's not focused particularly on terrorism cases, because these programs are more focused on the needs of the children, but it can also apply to children who might have been involved in terrorism-related cases. One of the distinct features of this program is it prefers community community-based programs, but it also provides institution-based programs. And it includes, for example, individual and family sessions, etc. And what are some of the challenges we have, especially when applying it at the community base, the perception and attitude of the people in relation to the children, because they are considered as threats. And how do we respond to this? We actually engage them in dialogues and show them the concrete benefits of how making them part of the solution in relation to making the society and their community safe is very useful, especially when it comes to threats of terrorism. We would also request our other juvenile justice practitioners who have practiced these programs to also give the success stories. Sometimes we would invite children if they allow us to also for them to speak in the public, to also tell how their lives have been transformed by these programs. So that's just some of the things that we do. But it's really very important that you have to provide concrete, we have to show them very concrete benefits for the community and how they can also be part of the solution to keep the community safe.
Thank you very much for that answer. And how interesting that your approach involves the children in figuring out what the solutions are and in identifying how to prevent other children from falling victim to the same thing and being agents of their own rehabilitation. A fascinating approach. And as I said earlier, very, very interested in talking more with the Philippines about its novel approach to the handling of children. We are out of time, so allow me to thank very sincerely the panelists from our panel number 2 for their descriptions of this complex challenge of treating children, both holding them accountable and respecting their rights, and of stressing the importance of a common child-centered approach to all of our work. I'd also like to thank the panelists from the panel number 1 for their passionate and thorough, thoughtful responses to the questions that we posed. At this point, on behalf of the entire team of the International Institute for Justice and the Rule of Law, I'd like to express my thanks to all of our speakers for such thoughtful and useful insights, to everyone who participated, and to the U.S. Department of State Bureau of Counterterrorism for supporting this event. Tomorrow is our practitioner level day, during which we will hear from speakers who contributed to the development of these notes, as well as from practitioners from the various regions that the IIJ serves. I invite you all to come back tomorrow using the links that we will be distributing to you after this session. For now, I thank you all for participating from across all corners of the globe and for sharing our interest in improving the treatment of children involved in terrorism cases. We very much appreciate your attention and look forward to seeing you all tomorrow. Thank you very much and goodbye. Good afternoon. My name is Gail Malone, and I'm the Director of Programs at the International Institute for Justice and the Rule of Law, or the IIJ, as we're called. It's my pleasure to welcome you all to the second day of the public launch of the IIJ Juvenile Justice Notes for Practitioners. Before we begin, I'd like to thank the United States Department of State Bureau of Counterterrorism for its generous support of our juvenile justice work and for its sponsorship of this event. I would also like to extend my thanks to the eminent speakers we will be hearing from today, and to all of you who are participating online from around the world. It is a true indication of the importance of juvenile justice that more than 450 practitioners from 59 countries on 4 continents have registered to participate in this event. As our Executive Secretary Tom Wookty said yesterday, the practitioners' notes that we dedicate today address a topic of utmost importance: how to respect the unique rights and interests of children involved in terrorism cases, whether as witness, victim, or perpetrator, while still protecting the public safety and holding bad actors accountable. These notes are the product of 3 years of expert meetings, peer review, and refinement, and reflect the best thinking on the topic from a multidisciplinary team of subject matter experts. The notes provide specific, timely, and practical guidance and examples to practitioners and policymakers on effectively handling terrorism matters involving children. Yesterday, we kicked off our launch with presentation from experts from UNICEF, the United States Department of State Bureau of Counterterrorism, the Nigerian Ministry of Justice, UNODC, the European Commission, and the Philippine Juvenile Justice and Welfare Council. In 2 panels, they shared their views on how best to ensure justice for children affected by terrorist groups, how to balance the need for accountability against children's unique needs for rehabilitation and reintegration, and how these practitioners' notes will help advance a common approach to these challenges. Today, we have the pleasure of welcoming an impressive group of practitioners, all experts in their own right, to introduce you in greater detail to each of the 5 practitioners' notes, one each for investigators, prosecutors, defense attorneys, judges, and detention personnel. We're particularly proud that many of today's speakers played a key role in helping draft the notes we are here to dedicate, and we anxiously await their commentary and answers to your questions. Before we begin, we appreciate that many of you have not actually seen or had the opportunity to digest these practitioners' notes. I will therefore turn the floor over to my colleague Emerson Cachon, who will offer you a brief overview of the notes, how they are organized, and the guiding principles on which they rely. I would first like to take this opportunity to recognize Emerson, who is the IIJ's resident expert on juvenile justice, and who was the driving force behind the finalization of these practitioners' notes and the organization of this event. Without his Herculean efforts, this event would not have been possible. Emerson, the floor is yours.
Thank you, Gail. Thank you, everyone. As the Executive Secretary mentioned yesterday, this event marks the publication of 5 different guides. So many of you have been hearing about the guide, the notes, since yesterday. So we are going to call on what those notes are. The Director of Programs, Gail Malone, just mentioned it. So we have 5 notes. We have the IIJ Juvenile Justice note for investigators, the note for prosecutors, the note for judges, the note for defense counsel, the note for detention personnel. And one thing very briefly I want to say, these notes are relevant to many other actors other than those specified on the cover as title of these notes. For instance, when I take the IIJ note for detention personnel, it's also relevant to practitioners such as social workers, psychologists, and specialized educators. So each note divided into specific action points provide practical guidance to practitioners on the implementation of the Neuchâtel Memorandum by sector. And it also provides a better understandings of tools at their disposal to handle children cases in a counterterrorism context. The note also includes examples of how countries have already implemented some of the principles highlighted therein. The purpose of today's panel is to present the content of the note. It's not to present the content of the note, but rather discuss some of the underlying principles which present current challenges to the practitioners we work with in the field. We will start with panel 3. Actually, yesterday we did panel 1 and 2. So we'll start today with panel 3, which will deal with the IIJ note for investigators and the note for detention personnel. To do so, I would like to introduce the moderator of this panel, Mr. Ibrahima Tunkara. Mr. Ibrahima Tunkara has been working as the National Director of Prison Management and Remand Education of Mali for almost 5 years now. He became a magistrate in 2005 and served as an investigative judge, then as a vice president of the Commercial Court of Bamako. Mr. Tunkara moved to the Ministry of Justice as Deputy Director of Civil, Commercial, and Social Affairs at the General Directorate of State Litigation, later as Technical Advisor to the Minister of Justice. Mr. Tunkara also served as arbitrator at the Arbitration Center of the Organization for the Harmonization of Business Law in Africa, or OHADA. Under his leadership and using his lessons learned from IIJ-led workshops, the prison administration in Mali created separate wings for children in 33 prisons between 2020 and 2021 to keep children in conflict with the law segregated from adults in compliance with international norms and standards. He is a double recipient of the honorary distinction of Knight of the National Order and Officer of the National Order of Merit of Mali. Mr. Tunkara, you have the floor.
Merci beaucoup, Monsieur Emerson.
Thank you very much. Thank you very much, Emerson. I'm having some problems in order to turn on my camera, but I hope that you can hear me well. I would like to say thank you to the IIJ, and I would like to say that it is a pleasure to be here with you all today. And it is a pleasure to moderate this third panel, that is to say, notes for investigators and detention personnel. This panel, during this panel, we will have the opportunity to hear from Ms. Irina Urumova and Mr. Michael John Langelar. As we were saying before, and as we said yesterday, the Memorandum of Neuchâtel was approved some years ago in 2016, and it is about the best practices when it comes to fight against the terrorism and especially how to deal with the children. I also have to say that IIJ organized over the time several national and regional workshops in order to provide a better idea of this memorandum and these guidelines. These guidelines take into consideration the several steps of the process that can involve children and all the other practitioners involved in this sector. There is to say investigators, detention personnel, but also judges and lawyers. In order to moderate this panel, I would like to start by introducing Ms. Irina Urumova, who is an international expert of the protection of children, the protection of victims and witnesses. She offers a technical assistance in these areas, and she has been offering this technical assistance for more than 15 years now. And she works especially in the field of victim and witness support, crime against children, sexual and gender-based violence, and child-friendly procedures. She has also served as international expert with the Council of Europe, training the national police on child investigative interviewing and child sexual exploitation and abuse in general. She also worked in different regions of the world, from Central Asia to Iraq, and also Eastern Europe and Mauritius. Irina Urumova is a rostered expert for justice rapid response, especially concerning international criminal investigations and child rights focus. And she also works for the UNICEF Europe and Central Asia Regional Office, especially for child protection. You have the floor now.
Thank you, Mr. Moderator. It is my pleasure to welcome everyone. I would like to start with a point that perhaps it is something that everyone present here realizes fully. Investigating terrorism offenses is a challenging and sensitive job, and when children are involved, doubly so. We know that children have suffered both the devastating impact of terrorism on their lives and an erosion of the rights of the child due to counterterrorism measures, sometimes failing to take children's distinct needs into account. Today, as I present the practitioner's note for investigators, I would like to focus on 2 action points from it. Not because others are less important, but because the issues addressed by these 2 points are largely interconnected and permeate the entire fabric of child rights aware response to terrorism. So let me start with practitioner's note action point number 6, which emphasizes the importance of focusing not only on the child's suspected involvement in criminal activity, but also on their victimization. Either, well, there can be like 3 scenarios here at least. A child may be victimized, and this serves as a root cause of their terrorist involvement. So this is exploited as a vulnerability factor. Or a child may be victimized by the terrorist group because of recruitment and use of the child, exploitation of the child for terrorist activities, or as both, most likely both. And here we have to realize that it's on the state to introduce and mainstream into operational guidance safeguarding mechanisms designed specifically for children involved in such acts. Some of the children who law enforcement encounter through investigations may not even be targets of the investigation, and some may be very, very young. So what does that mean on a practical level? I can give you a very good recent example of a state introducing such safeguarding measures, mainstreamed at all levels, from legislative down to operational guidance. And this is the Philippines, where some time ago, we saw a special protection of children in situation of armed conflict act passed. This act provides that children encountered in the context of counterterrorism operations must be immediately transferred to child welfare authorities. That means within 24 hours. This is, of course, a very promising practice, but there are many states out there that do not yet have integrated national child protection systems, unlike the Philippines, which has an integration national child protection system. So what do these states do? Understandably, they face a steeper challenge in following action point 6, even where there is political will. But this is hardly an unsurmountable obstacle. Luckily, we also have examples of countries that have been able to introduce child-friendly safeguarding mechanisms, even in the absence of an integrated child protection system. Let me give you the example of Kazakhstan, which was the first in Central Asia to start repatriating its citizens from conflict areas. And arriving families in Kazakhstan stay together in post-arrival processing centers. What that means is that returnee children receive services they need, and they are not separating from their parents while security vetting and investigative interviews are ongoing. Later, what happens is that adults against whom there is evidence of participating in hostilities are transferred to pretrial detention centers, while children are placed in communities. If it happens so that the parent with whom the child traveled needs to be processed through the criminal justice system and detained, and the child is left without an accompanying parent, they are not placed in institutions. They're placed in foster care settings with extended families. All of these children are enrolled in various programming activities specifically developed for this target group at community-based centers operated by government-contracted non-governmental organizations. Why am I saying this? To stress that reforms cannot be implemented in isolation, but require a multidisciplinary and multi-agency approach. Another action point I wanted to mention concerns viewing detention of children, and I mean police custody here because this is what the investigators note focuses on, but my colleague will also speak about detention in general. So viewing detention of children only as a last resort and for the shortest possible period of time. And that means 24 hours as a very maximum, and ideally even less. Again, sometimes there are circumstances when implementing this in practice is difficult, either because the tracing of parents or guardians is impossible or impracticable, or because the family want nothing to do with the child because of the nature of the charges that the child is facing. Ideally, the child should be referred to a service that can ensure proper supervision of the child in a community environment without the need to keep the child in custody. But this yet again underscores the importance of multidisciplinarity. Well, unfortunately, as the world is still reeling from the consequences of the COVID-19 pandemic, it's not over. This has raised new challenges as more children than ever are reported to law enforcement because of we have violent extremist recruiters using lockdowns to double down on engaging children who found themselves with plenty of time to spend online. This is, of course, a challenge for investigators, but even more so for educational authorities. I hope for a productive discussion and hope to hear about your challenges and your good practices, your solutions. Thank you very much.
Merci beaucoup, Madame Irina, pour
Thank you very much, Ms. Irina, for this interesting presentation, which allows us to take advantage of the notes for practitioners. And I will seize the opportunity now to introduce the next international expert, who's a specialist in detention services. He's a corrections policy officer at the United Nations Department of Peacekeeping Operations, Mr. Michael John Langelar. He started his career in Canada, where he had several different roles and functions. And his international career allowed him to get a diploma for his mission at Kosovo for the United Nations in 2003. And since then, he has played different roles in the United Nations and at the European Union level, as well as in Africa. He's very passionate, and he has given great contribution to a lot of work in prisons in the framework of awareness raising, accountability, management, classification of prisoners and risk evaluation, as well as safety and security in prisons. So the floor is yours.
Mr. Tanqueray, thank you very much for the introduction, and a huge welcome to absolutely everyone who is tuned in. I just want to start with, just mentioning the incredible opportunity to work with the IIJ, and specifically, on these notes, and working with practitioners from all over the world. I think it was a fantastic way to pull together the common stream of thoughts and practices from everyone who we worked with. And one of the things that I really noticed is that there's a significant varying degree of financial support that detention practitioners have from all over the world. And I think the challenge here was for us as a working group to really pull together the common threads. Those threads that have relevance in everyone's context within, the varying ministries, the varying human resource support plans, the allocation of assets and infrastructure. So it was a very interesting process, and we hope that we as a group put together notes that can speak a little bit to everyone's context. For example, Mr. Tanqueray mentioned, as a result of the notes and the discussions, he managed to have the separation of juveniles from the larger prison population. I understand this is an insurmountable task in his current working environment. So congratulations, Mr. Tanqueray. I know that's a really big feat. I also want to mention that, detention as an equal partner with other criminal justice actors is often, considered the poor cousin. And I don't want to harp on that, but it is a reality I think we need to take into consideration. Oftentimes under-resourced, oftentimes overcrowded facilities. But what I want to point out, and the basis of many of the action points we talked about, is that places of detention have a very significant push or pull influence over offenders, and in this case, juvenile offenders. At least it's said to have had, and we can get into that a little bit later. Starting with, and Irina also mentioned this in her presentation, the overarching principles, and there's many human rights standards for juvenile detention out there, are that, juveniles should only be placed in detentions as a last resort and for the shortest time possible. And, the custodial experience must, support the well-being, and that's the physical, psychological, and even emotional well-being of the juvenile. And because of that, there was this one quote that really struck me that Emerson, the IIJ, asked me to throw out there. And that's the long-term successful reintegration of children in conflict with the law will likely improve when children are not subjected to restrictive custodial measures. It's a packed quote, and to unpack it, we see the relationship between reintegration and custodial measures. We see this concept of restrictiveness and how it can influence successful reintegration. So that was a bit of the premise of how we identified the key points of the detention note. Just a couple of highlights I want to make. One, that we would never expect, our detention personnel to operate outside of their legal obligations in the countries in which they work, meaning they have law and they have policy that they need to follow. And the last thing we would like to do is have them operate contrary to any of those law and policies that exist. So the way we approach these notes, for us anyways, was to, one, find the gaps that exist in the law and policy, and then creatively apply the principles of the human rights standards to fill the gaps, to find where do we have movement, where is there, opportunity for influence. And again, what we'll see is the notes become very, very practical in this sense. And it's something that can be implemented at low cost and with the influence of the practitioner themselves. A couple highlighted points I would like to make before we move into a question and answer session is that juveniles suspected or convicted of crimes of terrorism and juveniles radicalized to violence, or another word for that, which we see out there, is violent extremist juveniles. They may not be one and the same. And this may not often be determined through the police and judicial process. So in part of the notes, this highlights the importance of the risk assessment process, especially at the point of admission into the detention facility. And there is a lot mentioned in the notes on the risk assessment process and even the rehabilitation process, the risk, need, and responsibility principles. Again, there's a lot of literature on this. There's great experts out there who we worked with who would be able to share their experiences. Would also like to mention that, out of all the conversations and working groups we had, probably the most important aspect that we determined that was relevant to everyone's context was the relational aspect between the detention staff member, expert, and the juvenile offender. And it was through that relationship, that we identified in action point 6, that it can either have a hugely negative effect or a very positive effect on that sort of custodial experience. And I think what we were looking at there was, if the relationship is of a negative nature, it has huge influence over pretty much the entire sentence plan for that young juvenile. Everything in terms of the interpretation of risk, it'd be clouded by, a negative relationship with staff members. It probably has a lot to do with the influence of, reducing stigma through the language used even. And we saw a lot of that, what titles are being placed on young juvenile offenders. Anyways, what we did notice is that the relational aspect is probably of the most important aspects. And the other thing we identified is that the cost of establishing and maintaining those relationships, while relatively inexpensive, is significantly costly on the staff member themselves. It is emotionally draining, and I think we understand that. So again, a lot of emphasis placed on, the identification, selection, training of detention personnel. Because I do think, and that's action point 13, we touch on that, where we identify that staff members are probably the most valuable resource and the most influencing resource over that young person while in an unfortunate circumstance and in a place of detention. And lastly, one thing that I think we would like to just highlight, and again, it's in the notes and it's action point 14, is this concept of inspection. Now, we noticed that, some of the countries we work with use the concept of inspection, others consider it, oversight, even accountability mechanisms. But for many practitioners, what we saw is that there is this sense of negativity around judicial inspection, about oversight mechanisms for the facilities in which they work. And I fully understand that, because I've seen many juvenile facilities where when there is an inspection, it's done through a negative lens, looking to place blame, looking to find all the faults. Now, while understanding the gaps is hugely important, I also think that practitioners can use these inspections, and I encourage them to, participate in these inspections to identify the gaps that exist, to identify the challenges, to identify the lack of resources, and flip it over, and it can be really used to help create the visibility and advocacy around what these facilities are and should be. So it is just one of those areas that, again, there's a lot packed into action point 14. But for me, working with many services all over the world, I do believe that the inspection process can be used to protect, to enhance the reputation of practitioners, and identify their professionalism as well. And this is the other aspect I appreciate with the IIJ. Many of you tuning in are not just detention practitioners. And I think there's a level of advocacy amongst investigators, amongst the police, amongst the judicial personnel for the challenges that do exist in these detention facilities for juveniles. And again, if it is judicial oversight that exists, I'm hoping that there is some sensitivity to the challenging work that detention personnel undertake when working with these juveniles. And Mr. Ibrahim Tankara, back over to you. Thank you.
Merci beaucoup, Monsieur Mike.
Thank you very much for this comments, high quality comments, which I really appreciated. And with this, we have taken notes of the key elements of the notes, especially as far as officers in prisons are concerned and detention personnel is concerned. So thank you very much. I would like to thank both speakers because your insights have been very useful for a very practical approach. And it is clear that we always have to protect the children's best interests. So you have really highlighted all of these elements. Thank you very much once again for your comments. Now, I would like to ask you a couple of questions as moderator in order to get deeper into the topic of this panel. So I will start with Ms. Irina. If I may, this is my question. The measure to be adopted according to point 5 of our notes states that police has to carry out an investigation before the child is implicated in a process. We understand that the community may be affected by this kind of approach. So what shall we do in this case? The floor is yours, Ms. Irina.
Yes, precisely. So basically, it concerns police granting diversionary measures before arrest in appropriate cases. Actually, the backlash from the community is very real, and actually in all countries where diversion has been introduced, where I was involved in this or that capacity, I could see a huge degree of skepticism towards diversion with regard to children in conflict with the law in general. And when it comes to children who are implicated in terrorism offenses, doubly so. But, it's the question of people misconstruing the concept of diversion. Diversion doesn't mean impunity. Actually, this is the contrary. Diversion is about avoiding stigmatization. It's not, it's about avoiding the label, the, something stuck to the forehead of the child for the rest of their lives saying, I'm a terrorist. It's about avoiding that. which is definitely not helpful for a child to be stigmatized for two reasons, and they're very psychological. First, it is children in general, children in conflict with the law resign to the idea, basically it shapes them. It's somehow the label of criminality is something inescapable for them. But on the other hand, it can even be a badge of honor in certain circumstances. And when it comes to children implicated in terrorism offenses, it could be used actually to further promote violent radicalization of the child, to discourage disengagement. So it could be we're making things counterproductive by stigmatizing the child. But diversion never means lack of responsibility. Diversion should be voluntary, first of all, so the child should realize that by agreeing to diversion, they're making a commitment. And it's a commitment to fulfill the requirements of their individual diversion plan. And that's not easy. So basically, it promotes responsibility without stigmatization. When it comes to communities, well, they just have to be prepared. Well, I spoke about multidisciplinarity. I guess engaging actors that can advocate on community level is a big part of it. When it comes to diversion, you have to really prepare the ground. And from then onwards, when diversion is introduced, Michael made a very, very good point, saying that there should be, and that concerns every field. It's not only about detention or investigations or diversion, it's about everything that is novel. So we look for gaps in legislation, in regulations, to see where we can fit these little measures that would not be breaking the law, but at the same time, we don't necessarily go for amendment before we see to what extent it is effective. So we start small, and with diversion, that's actually a very, very good way to get things started. And well, I know countries that have actually done just that, but then you have to be very conscientious in monitoring the impact. And if you can demonstrate to the community that these children are more likely to disengage, these children are more likely not to reoffend, then you have a real argument, and people would actually not mind more bold steps. And then you can go ahead and propose amendments to the law, etc. So this would be, sorry for the long answer, but I guess the issue is quite complicated and multifaceted. Thank you.
Merci beaucoup, Madame Irina.
Thank you very much, Ms. Irina. Your answer was very clear and precise. And we'll get back to you with another question soon, but I will now turn to Mr. Michael.
Alors, à Monsieur Michael, excusez-moi, Monsieur Michael, vous avez mentionné, Monsieur Michael, vous avez mentionné
you mentioned that prisons can have an impact on the children who have committed crimes. Can you please add some comments on this, Mr. Michael?
Thank you very much. And I think it was the comment you're referring to, that we often say that places of detention can have a strong push or pull influence over those in detention. This comes back to I work with a Sharia law expert. He's a judge, and he continually uses the story and the analogy that the birth of ISIS was really inside a prison facility. And when you unpack that, I think you break it into several different aspects. And, you know, the common themes, at least in this analysis, was the restrictiveness of the environment, the tight controls of the environment, the fact that the conditions were deplorable, meaning, you know, maybe the nutritional value of the food was very poor, the ventilation, the lighting, very hot cells where you spent, you know, 23 hours a day. And what they found is while conditions for everyone were not very good, but they were even worse for those who have been labeled, as Irina was talking about, that label of terrorist. And basically that's what we're saying is the push-pull. Either individuals based on, you know, the environment, and again, back to the relational aspect, if detention personnel are very strict, which order is a must, discipline is a must. I don't think anyone's denying that. But if it's authoritarian, if it's really pressing to the point where it's inhumane, it does drive people away. It defeats the legitimacy of the juvenile facility altogether. It doesn't contribute to those broad principles we were talking about a nurturing environment. And it can cause people to, especially juveniles, to identify with groups that may belong inside the facility, draw closer to them to find self-worth, to identify their self-identity. And it can actually harden the ideological, you know, aspects of the individuals, or just even push them to where they feel they belong. A lot, very, very close to, you know, the theories of gang formation in prisons, very, very, very similar. So what we tried to do with the notes was identify that not only if we try and align better with the guiding principles of the international human rights standards, but go beyond that and place effort on building relationships like that, you know, trusted individual that you can rely on. The fact that, you know, they're having their nutritional requirements met, they're getting opportunity for activity to grow as kids grow, juveniles outside of these detention facilities have the opportunity, much like them, education, just to engage in meaningful activity. That's what we're saying in terms of push-pull. The environment itself can really drive people away and harden those sort of anti-establishment thoughts, or it can really try and pull and work towards the rehabilitation, reintegration aspect of trying to normalize the environment as much as possible based on the risk assessment. Now, we fully understand every juvenile person is different and unique and complex. And that's part of the process of this multidisciplinary approach through risk assessments, identifying needs, applying regimes based on, you know, what is manageable with this individual. So I know I went around in a lot of circles, but I do think that the notes speak a lot to push-pull factors, and really restrictive environments, back to the quote I mentioned, does have an impact on successful reintegration. So Mr. Tanqueray, thank you so much for the question. And again, there's a lot more to unpack with that answer in the notes. And if you look at the specific examples in the notes, I think that you can get a sense and an idea of what countries have done specifically to try and move juveniles away from those groups, whether they be terrorist groups, violent extremist groups, gangs, and into, you know, some sort of pro-social reintegration strategy.
Merci beaucoup, Monsieur Michael.
Thank you very much, Mr. Michael, for this clear answer. And it is clear it is important to create a normal environment within detention areas. And I will get back to you with my second question, but I will first ask my second question to Ms. Irina. So the third question is for you. The Convention on Children's Rights states that children who used to be part of terrorist groups have to be protected. So detention should be used to protect these children, although it is not one of the elements included in the convention. So the floor is yours. What do you think?
Thank you. Well, basically, yes and no. We have to implement a risk assessment, and that means the risk assessment of risks posed by the child and of risks posed to the child. And so it has to be a very balanced exercise. Actually, it's a good idea to have structured tools that actually are adapted for the specifics of children. And here, well, yes, unfortunately, sometimes if a child is released back into the community, they would face serious risks. That means very likely and with potentially catastrophic consequences. But there are always, or at least in most cases, there are solutions that fit somewhere in between that serve to protect the child without going to the extreme. And again, it comes to, well, the children can be relocated and placed in communities where they would be less known, maybe in a foster care setting, or because there are professional foster care families in some countries that are trained to work with children in conflict with the law. And it is a possibility if a child is not known, they would face less risk of retaliation. There can also be options of placing them in some kind of residential facilities, but they're not detention facilities as such. Again, to protect the child. Of course, we have to look also at the risks posed by the child, but assuming that there would be no conflict between placing that child among the population of the residential facility where other children are placed. Well, in exceptional cases, yes, protective custody may be an option for a very short time until a better solution has been found. You have to look at it as the issue of protecting victims and witnesses. And I'm specifically not mentioning here traditional victim protection schemes because I know that they're extremely costly and many countries just are unable to implement them. So I'm looking at something that would be feasible for a country to implement with the infrastructure that is likely already in place. But again, just to emphasize, risk assessment is key. If the child says, I'm afraid to go back to the community, it doesn't mean they cannot be released. Maybe they can be released, but with additional precautions, because our aim is, in any case, is to make the child reintegrated and to help them live their life as a productive person. Thank you. Over to you, sir.
Merci beaucoup, Madame Irina. Nous avons bien noté qu'il est très important d'évaluer les risques et de protéger les enfants en toutes circonstances et éviter les mesures les plus extrêmes. On me signale que le temps imparti est presque terminé, mais je voudrais juste c'était une dernière question relative à la récidive, si la détention était nécessaire en cas de récidive. dire, mais
concerning the
le
fact
temps
that
imparti
maybe
est terminé.
detention and
Je donne la
custody can
parole
be
à
necessary in case
Emerson.
of
Ça a été un
reoffending.
plaisir pour moi de modérer ce
But
panel.
actually, we have no
Merci
more
beaucoup
time for
IIJ.
this question. I just would like to
Emerson,
thank
à
the
vous la parole.
different speakers of this panel. Thank you so much. And Mr. Emerson, you have the floor now.
Thank you, Mr. Tunkara. Now, we are moving on the next panel, and really, for sure, we will talk about some of the aspects that we were not able to cover during this first panel in the next panels. Thank you all. So our next three panelists will discuss the IIJ note for defense counsels and prosecutors. So they will share their perspectives on the role of defense counsel and the prosecutor in preserving the unique needs of children affected by or involved in terrorism-related offenses. The first speaker of this panel is Mr. Ali Abu Quraish. He is a Deputy Director of the Prosecutor's Office of the Governorate of Hawali from Kuwait. Prior to this position, Mr. Abu Quraish was a public prosecutor, more specifically at the Financial Prosecutor's Office of General Funds and Anti-Money Laundering from 2014 to 2016. Mr. Bukraish also has an extensive experience in prosecuting juvenile cases as a juvenile prosecutor. It is an honor for us to welcome you here, Mr. Ali Bukraish, to discuss some of those issues highlighted by the note with us. Mr. Bukraish, you have the floor.
Firstly, I would like to thank the IIJ, the International Institute for Justice, to allow me to be part of this meeting today. I'd like to talk firstly about, after I have viewed all the notes of the made for practitioners and those that concern prosecutors, I found that and I thought that Kuwait in this memorandum also there is a special law for juveniles issued in 1983, and it has been revised in 2015 about the method of treating with those suspected in being involved. So that these norms have to be respected during the investigation process. No matter how severe as the crime or the act. I would like also to say that the special law we have for the juveniles in Kuwait, the prosecution, of course, they carry out firstly the investigations. All these minors that are suspected, and of course there are specialists who have to carry out this investigation with the juveniles. So of course these experts they have to be graduated from a special institute, and they have to be they are trained how to deal with children and how to keep and respect all the protection laws provided in the Kuwaiti law. the age for the responsibility, I would like to clarify that when the child reaches 7 years old, then there are two categories of ages in the Kuwaiti. The first category, from the age that they have reached 7 years old, but the second category, those who already became 15 and above. The first category, of course, they are not subject to any, no matter how severe are the consequences of such crimes that they were pulled into, they are not responsible, and the law is, there are special procedures, protection procedures. But for the second category, those who have completed 15 years old and above, in case they carry out any, they are involved in any crimes, then they, of course, the punishment would be decreased noticeably, but they will be prosecuted. Anyway, they cannot be punished in all cases since they are minors, all of them. So there are special courts dealing with these cases. So they are not punished, they are not given any serious between 15 and 18 years old, but instead there are special programs of rehab. We are also following the memorandum. Of course, those all those juveniles, they are the state has to provide the Council of Defense for them, a state council of state defender, and a state also investigator. These are among the guarantees that I'd like to underline in the law of juveniles. Of course, it is not allowed to send them to prison during the phase of investigation and during the trial, the prosecution, even if it is if we are talking about a crime of terrorism. If there is a need to keep this minor, then he can be kept in a special center. That's if he is below 15 years old. If he or she is above 15 years old, then he can be kept in a special detention for juveniles, a special detention center for juveniles, and it's equipped also to receive the juveniles, but only for a period of time not above 3 months. So of course the law also emphasizes on this on the confidentiality of the trials related to children. It is not allowed for mass media to be present at those trials, to respect the privacy and of these children. These are among the protection and laws guaranteeing the privacy of that is of course in harmony with the memorandums that we were inspired to. So in all cases of terrorism where children are involved, we had a case at the end of the year 2020. We had of course special police trained to investigate a juvenile who was 15 years old. He joined the ISIS, Daesh, and this was outside Kuwait. And it has been agreed among the two juveniles to burn in a special praying place for one of the religions in Kuwait. So at that there was a special order by the public prosecutor to arrest temporarily these juveniles, and they were having all explosive devices, and they had weapons, and they were armed. So they have been investigated by a special prosecutor, a special investigator trained to deal with children, with minors. Of course, this investigation has to be in presence of the Defense Council and also an expert from the Ministry of Social Issues and special expert in social assistance. Then they were brought in front of the court, and they were accused of those crimes. Thank you for listening, and I'm ready to answer if there are any questions on regard. Thank you for your kind attention.
Thank you, Mr. Bukrais. We noted with great interest that the Kuwaiti law contains some of the principles highlighted in the note. We noted the specialized training that you provide to prosecutors, to police, and police to investigate children aged 15 and above years old. We also noted with interest that detention children below 15 years old cannot be detained. They can be detained only if they are 15 years old and above, but in a special detention center, which is great and interesting. And thank you also for sharing information regarding the protection of the information of the child during trials and other good practices highlighted in Kuwait. Thank you, Mr. Bukrais. Our next speaker will be Mr. Thomas Black, federal prosecutor in the USA. Mr. Thomas Black spent more than 35 years as a federal prosecutor in the US Department of Justice in Washington, D.C. He worked for 12 years in the Department Office of International Affairs, OIA, where he served as an associate director. Mr. Black managed international extradition and mutual legal assistance requests between the United States and its law enforcement partners in the Western Hemisphere, Europe, and Asia. His cases involved a broad range of transnational organized crime matters, including terrorism, international narcotics trafficking, human trafficking, arms trafficking, and large-scale fraud schemes. Before his time at the OIA, Mr. Black served as an assistant US attorney, prosecuting local and federal offenses in Washington, D.C. Since his retirement from public service, Mr. Black has worked as a consultant on several projects with the International Institute for Justice and the Rule of Law, the IIJ, and Interpol. Tom, I give you the floor.
Thank you, Emerson. First, I'd like to thank the IIJ for organizing this launch. It's been a great pleasure working with the Institute, and perhaps the best part is getting to know all of my dear colleagues at the Institute and getting to know people, prosecutors, investigators, and other juvenile justice officials from around the world. It's truly been a pleasure, and I thank you. For my presentation today, I'm going to present a hypothetical or practice case illustrating two very different outcomes in a matter involving a child suspected of participating in a terrorist act. The different outcomes, as you will see, will result from different decisions that prosecutors make in the two variations. So let's consider the first hypothetical scenario. Prosecutor 1 received a police report about a bomb that went off in the city's largest public park. 2 people died and 10 others were injured. The surveillance video from a nearby store showed that just before the explosion, a male whose face is clearly visible and looks to be 18 to 22 years old, carried a backpack into the park and left it under a bush. The male then ran out of the park just as the explosion went off in the place where he had left the backpack. The police found and arrested male shortly after the incident. Male claimed to be only 16 years old and said he acted alone because he wanted to see people die. The police contacted male's parents, who said he was only 16, but looked much older. The police decided that male and his parents were lying about his age because they knew he would be more severely punished as an adult if he were 18 years or older. Male's defense counsel asked to speak with the prosecutor because counsel thought his client was only 16 and had been coerced by some unknown adults into committing the crimes and confessing. The prosecutor refused to talk to the defense counsel because she felt she had a very strong case and the public was demanding a swift arrest and conviction. The prosecutor ordered male to be held in an adult pretrial detention facility because she thought he was over 18. 2 months later, at the public trial, the judge rejected the defense's claims about male's age and his coerced confession for lack of proof. Based on the prosecutor's evidence of the surveillance tape, male's apparent age, and his confession, the judge imposed a sentence of 25 years in an adult jail for murder and domestic terrorism. Public reaction was very positive for the prosecutor. Now let's consider how a different prosecutor, Prosecutor 2, may have handled that same case. Same facts, same child named male, same defense counsel, but a different prosecutor. Based on the surveillance video, Prosecutor 2 also thought male was at least 18 to 22 years old. Prosecutor 2, however, decided to further investigate because of male's and his parents' claims that he was only 16. Prosecutor 2 sent social workers and the police to look for records of male's birth. Neither the parents nor male's school or place of worship had any records. Eventually, however, the police identified the hospital where male was born. The hospital had a copy of a birth certificate that showed male was born in 2006 and was only 16 when he committed the offense. Pending the disposition hearing, Prosecutor 2 asked the judge to order male to be held in a juvenile detention facility where he was assigned a counselor and received family visits as well as medical, psychological, and social services. Prosecutor 2 also decided to talk to the defense counsel, who said he had heard from people in the area but could not prove that male and his family had been coerced into the bombing plot. Prosecutor 2 ordered the police to investigate further, but the family refused to talk anymore with authorities. Eventually, investigators linked the explosive device to members of AZM, a terrorist group known to commit violence, kidnapping, and extortion. The police conducted several undercover operations and located AZM, whose members confessed they had kidnapped male's sister and threatened her family with her death if her brother did not plant the bomb and confess to the crime. Prosecutor 2 recognized that male's confession had been coerced and was not an accurate account of what happened. The prosecutor did not use that confession against male in the juvenile disposition process. She also concluded that Mail had not acted completely voluntarily when he participated in the bombing. Prosecutor 2 and defense counsel collaborated and asked the disposition judge to order that Mail be sent to a residential juvenile rehabilitation center for no more than 2 years, where he would receive intensive psychological, social, educational, and employment counseling. The center would also provide Mail and his family with group counseling. Now, with those two outcomes from the same factual pattern regarding a terrorist bombing, I ask you, which prosecutor obtained a better result? And in answering that question, I invite you to refer to the practitioner's notes and the various action points in those notes to identify the decisions that the prosecutors made in each of these two factual contexts, and determine for yourself which outcome better serves society, the child, and the integrity of the criminal justice system, including juvenile justice. With that, I conclude my remarks. Emerson, I turn the floor back to you. Thank you.
Thank you, Tom. It goes without comments that during a live discussion with participants to a training, this will be a very interesting discussion. So Mail, who made confessions, and prosecutors 1 and 2, who provided different outcomes to the case. So thank you so much, Tom. This is an interesting case, and I wonder if our next panelist can react to that case. With that, I'll move to our next panelist, who is a defense counsel, Ms. Julie McConnell. Ms. Julie E. McConnell is a professor of law and the director of the Children's Defense Clinic at the University of Richmond School of Law. She worked in juvenile justice for more than 25 years and specializes in holistic trauma-informed representation and client-centered practice. She previously served as a criminal legal system policy advocate, a public defender, and child abuse and domestic violence prosecutor. Ms. McConnell is a frequent writer and presenter on juvenile justice issues and is co-editor of the book Juvenile Law and Practice in Virginia. She also regularly consults as a juvenile legal system expert in Virginia criminal cases. She is currently chair of the Virginia Advisory Committee on Juvenile Delinquency and Prevention, chair of the Virginia Bar Association's Commission on the Needs of Children, and chair of the annual Robert E. Shepherd Jr. Virginia Juvenile Law and Education Conference. Julie, I give you the floor.
Thank you, Emerson. Good afternoon, everyone. It is a pleasure to be here with all of you. Thank you to the IIJ and my esteemed colleagues for focusing on this crucial issue. When a bombing such as the one that Mr. Black described occurs, the community is understandably anxious for accountability. What we have to recognize, though, is that young people are especially vulnerable to being manipulated, trafficked, kidnapped, or forcibly recruited into terrorist acts. Once these young people are recruited, they become even more susceptible to terrorist control and indoctrination, as we've heard over the last few days. Sometimes that indoctrination and manipulation includes the use of drugs and the threat of harm to their families, as Mr. Black described. Other factors that can lead children into terrorist activities is poverty, a need for protection in their communities, cultural threats, a sense of religious duty, and also the promise of economic stability that can come with involvement in a terrorist organization. All of these factors can serve as strong motivation for children who are living in communities where they don't feel safe. Sometimes young people are recruited by family members. Sometimes they're led to believe that in Mr. Black's example, that the only way they can protect their family members who have been kidnapped is to set down that bomb, as Mr. Black described. And I want to note also that girls are especially vulnerable to terrorist recruitment, and we need to have special focus on girls, given the gendered social roles in many countries and those young girls' exposure to sexual and domestic violence. Given all of this, it's clear to me that our strongest counterterrorism tool is to build a strong social safety net that is focused on protecting children from these vulnerabilities. Again, as was repeatedly discussed yesterday, we must recognize that these children are victims first. So let's consider, as Mr. Emerson invited me to do, the case that Mr. Black presented. How should a defense attorney respond in a case like this? So as we know, due to the special rights accorded to children by international law and standards, the role of defense counsel is extremely important and takes on unique significance. Defense counsel is in a unique position to access records about the child and to assess their physical, emotional, and mental well-being, to understand their educational status, any educational disabilities they may have that would make them even more vulnerable, and to take care to carefully explain the procedures in the case to a child using child-centered, appropriate language that fits the adolescent development stage of the child. It is a very different conversation than we might have with adult clients. We should also very carefully investigate the circumstances of the terrorist act. And in the case that Mr. Black described, it would be very important for the defense attorney to look into the AZM terrorist group to determine whether the types of bombs that they use are consistent with the one that the child had here in his backpack, to investigate whether the sister was kidnapped. All of these things can help us to create a viable defense that can help prosecutors and judges see that this child was a victim first. Counsel should search for facts that are favorable to the child client that can be used in pretrial motions. For example, a motion to try to keep the confession from being used, given that it was coerced by the situation. We want to be able to take that information to prosecutors in advance to hopefully divert the case away from the court system altogether. If we are not successful with the prosecutor, we can bring those same arguments to the investigating magistrate or judge and hopefully argue for dismissal of the criminal portion of a case of this nature, given the extreme coercion involved and the fact that this child clearly felt he had no other choice but to try to protect his sibling. There are ways to handle these matters without there being criminal charges. We can put services in place. We can remove the child if necessary, if there are other family members that are involved in terrorist activities that would further indoctrinate the child if the child went back home. And those are all things defense counsel is in a unique position to present to those who have authority to make decisions in these cases. And we should always remember, first and foremost, that no child recruitment into terrorist activity can be considered as fully voluntary, given the limited cognitive skills of children. Their brains are not fully developed until they're at least into their mid-20s. And when they are under 18, they really do not have the skills yet to assess how to escape these types of situations. They are victims of their circumstances. They don't have the resources. They don't have other families. This is their family, and they don't have the choice to go and live somewhere else in many cases. And that is why they are so uniquely vulnerable to the recruitment tactics of terrorists. We must always advocate as defense counsel for pretrial release and recognition that the child is a victim. If the child does have to be detained, if that is the decision the prosecutor and the judge make in your case, then at the very least, we must argue for detention in a specialized facility for children rather than in an adult jail. When children are held in adult jails, they are extremely vulnerable to violence against them, as well as further recruitment and indoctrination. It is, as we said yesterday, the best place to recruit future terrorists. So we don't want children to be in that situation where they have no escape from those who are trying to force them into further terrorist acts. Additionally, we must gather information to mitigate our client's involvement at all in the alleged offense. We can argue, as in this case, that the child really felt he had no choice and would put his family at great risk if he didn't follow through with this act. That doesn't mean that it was right and that there should not be some way of addressing it, but we must recognize that children often cannot escape these circumstances. And we should also make immediate contact with any social workers that are working on the case. In this case, the information that was gathered to show that the child was only 16, we want to make sure we have access to that and to those who gathered that information. And we need to have immediate contact with the family to corroborate the child's version of events. So, in other things that would help us in investigating the case and putting together that argument would be to gain access to any surveillance video that may have been taken at the scene, to further try to document through birth certificates and other documents that his birth date is in fact one that would make him 16. We want to find out if other AZM members have confessed or are engaged in similar tactics in the past that can help us make the argument that that's what was happening here. Did our client make any particular statements beyond this confession? And we want to make sure we have every statement our child made so that we can see the pattern there. Did he only confess once he was told some of the details that he didn't know, that he could fill in? And there are many, many examples in child cases of false confessions. So it's important to look at what it is that the child said and when. Did they know that information independently, or did they only say it once it had been raised by the investigators, inadvertently perhaps, during the interrogation? So it's important to, if we can, get any documentation, video if available, of any interrogation that took place of the child. Other documents that we want to also try to collect in cases like this, and any reports, would be those from counselors that had worked with the child, medical personnel who examined him when he came in, a psychologist who may have done an evaluation, social services, as I mentioned earlier, and the detention facility itself. Have they been documenting his behavior if he's being held? Is there information there that might be useful to us to show why he would have been vulnerable to coercion? And additionally, if possible, gathering educational records can shed a lot of light on the way the child is functioning in school, what level they are, whether they would have even understood what was happening, the questions that were being asked. There may be evidence that the child suffers from diminished capacity, and it's always crucial that defense counsel present that information as early as they can, so that prosecutors can see that this case is different, that this child should be treated differently than an adult would. What is their stage of development? Is there mental health impairment? Have they suffered extreme trauma that could have interfered with normal brain development? It's well documented in science that trauma has a tremendous impact on the way children develop. They can develop a tendency to either fight or run away or freeze when confronted with similar trauma to what they have experienced in the past. And that may be relevant to the way they acted in this case. So investigating that is key. We also want to ask the court for an investigator if your country allows that, because an investigator can help you put together the information in this case that AZM uses these tactics to manipulate children and force them to participate. There may be a longstanding pattern of this sort of engagement of children that we can use an investigator to put together to present to the prosecutor and to the court and to the community. Because as I said earlier, we know that in these cases, the community is asking for accountability. And so the only way a prosecutor is going to be able to respond to that when there has been multiple deaths as a result of a bombing is to present enough evidence to the prosecutor that they can show that the person who is responsible for this is the person at AZM, not the child, and that we need to focus our accountability on those who truly are driving the ship. And also, we may be able to find witnesses in the community who have evidence about these tactics that AZM uses, and even in this case specifically, so that investigator can help track down those witnesses to find out whether this has happened to other families in this community. We can also ask the investigator to corroborate the actual kidnapping so that we can present that evidence as well to the prosecutor in the court. We also need to speak with the sister if possible, if she has been returned. If she is willing to speak with us or to our investigator, it can be a crucial part of putting the case together to have her perspective on what occurred. Finally, we need to carefully review that confession and make sure that it was not the subject of coercion. And in many of these cases, we are going to find that these confessions are given without access to counsel or family to advise the child about whether to speak. And so we have to make sure that we're addressing that as well as we can in the criminal legal system. That access to counsel is key. And so we should always agitate for counsel to be present before any interrogation of children occurs. And make sure that the child understood even what he was being asked and that it could be used against him in a later criminal prosecution. Was he allowed breaks, food, or rest during the interrogation? These are the types of questions defense counsel must ask. So this case obviously gives us a lot to talk about, and I look forward to your questions and hearing more about what the other my colleagues on the panel have to say about this case. But I want to remind all of you that defense counsel play a crucial role in ensuring justice and fairness in the legal system, and honestly, in preventing terrorism. We can do so much to help the community recognize best practices for how to respond in these situations that always recognize children's rights and protections, and that they are so easily victimized by these ruthless adults who know that they can make them do what they need them to do. And just remember that you are the last line between your child's freedom and incarceration. And you must always carry that burden with pride and recognize that you are a key player in the team that can address this issue. We must recognize that defense counsel is just as crucial as all the other roles that we've talked about the last 2 days, and we can be your partner in preventing terrorism. Thank you.
Thank you, Julie, for this brilliant feedback on Tom's hypothetical case. Yes, many of the principles that you highlight, Julie, thank you so much for that, have been discussed in the note, in the defense counsel note. So for a quick recap, we note that defense counsel can rely on not only on the police report, but also on a report from other actors involved in providing services to the child, like social workers, like psychologists. They can use that to build their case to defend the child in front of the prosecutor or the judge. The use of witness in the community of the child also is key, and you mentioned that. Thank you for that. Another aspect is the careful review of the statement made by the child in during questioning by police. How do we make sure that those statements were not coerced, and so on? So yeah, these are key elements that give food for thought and that provide certainly enlightenment to many of the participants listening to us now. Now we're going to move on to questions. We have a lot of questions from the floor as well. For the interest of time, we may not be able to answer all the questions. We have selected some of them and share them with our panelists. To start with, I will turn over quickly to Mr. Bookrice for the first question. Mr. Bookrice, what is the basis for determining the age of a child suspected of a terrorism-related offense, for instance, in the state of Kuwait? Thank you.
the parameter that we build on to determine the age of the minor is it's of course firstly the birth certificate and any other documents that can support. But in some cases, maybe we're not able to obtain these documents. So in that case, we have to bring this minor in front of a medical group of experts to determine his age by examining him and examining also the tooth, and they can they determine approximately the age of this minor. Thank you.
Thank you, Mr. Abu Quraish. My next question would go to you, Tom. Curious to know, isn't it the role of the defense counsel to determine the child age and whether the confession was coerced? What would be your role in that? Have the floor, Tom.
Thank you, Emerson. My response to that would start with the proposition that certainly primarily a defense counsel is going to want to investigate the facts that can be used to present the defense of the child accused of the terrorism. But the prosecutor also has a very strong interest in knowing all of the facts of the case. Just like in any criminal case, a prosecutor has a responsibility, a special responsibility, to fully and fairly investigate all of the facts, whether they're helpful to the prosecutor's case or harmful to the prosecutor's case. Because in the end, the prosecutor is supposed to do justice, not just win and get convictions. So following that basic principle that all prosecutors should be following, we come to a situation with a child accused of a very serious crime. We should follow that same principle in wanting to know all of the facts. So when a prosecutor gets a case with a person whose age is really important to determining how that case is going to proceed, the prosecutor has a strong interest in knowing exactly how the age is going to be determined for that child. Because as we saw in the example, it could result, on the one hand, of someone being sentenced to 25 years in an adult facility, when in fact, that child is only 16 years of age. So in my example, the prosecutor wants to find out, or should want to find out, really what the child's age is so he or she can make the proper decision of how the case proceeds. Likewise with confessions. We know that confessions from children are often the result of coercion or manipulation or misunderstanding or just a lack of comprehension on the part of the child about what's happening. Prosecutors need to understand that. And when you receive a confession from a child, you should find out all of the facts regarding how that confession was made and under what circumstances, so that you will be able to make a full and fair determination of how that confession will be used or affect the case. And I would just say in general, Emerson, the question raises a kind of a general point for me. Prosecutors listening to this launch will, I'm sure, appreciate that prosecuting a case of terrorism involving a child is immensely complex. And you have to know as a prosecutor, not only the international standards that apply to cases involving children, but you need to know your national law. You need to understand the vulnerabilities of children. And Ms. McConnell outlined a number of those vulnerabilities and how they can affect the case. you also need to understand what your national resources are available to you as a prosecutor in dealing with cases involving juveniles. That's a lot to get your head around and to understand, and it does call for specialized training and specialized units and even specialized courts to deal effectively with accused children. And one other thing I would like to make before I end my answer is that prosecutors need, I think, to perhaps think of accountability a little bit differently when they consider the trade-off between the so-called trade-off between accountability for a very serious offense, in this case, planting a bomb, and the interests of the child and the community in having that person rehabilitated and reintegrated into the community. Obviously, the public may well clamor for severe consequences, even for a child actor in the face of a horrendous terrorist bombing. But accountability, I would think, does not have to be thought of only in terms of incarceration or even in terms of punishment. Having a child voluntarily and honestly accept responsibility for the act, show remorse, have recognition for the harm that was created to the others affected by his or her act, and some sort of reconciliation with those injured parties, along with the appropriate counseling and the increased chances for rehabilitation and reintegration, I would submit is a form of accountability. It's a heavy form of accountability because it takes a lot of work and a lot of honest commitment on behalf of not only the child, but parents, social workers. So prosecutors, I think, have to have a different perspective when approaching a case involving a juvenile accused of terrorism, and immediately be sensitive to the facts that this is a different legal regime we're operating in. Children have special rights and they have special vulnerabilities. We need to keep those in mind. Thank you.
Thank you, Tom. In short, the prosecutor is here to do justice, not just to obtain a conviction. This is a strong message, and I'm sure everyone on the floor, all the prosecutors among the participants hear that message. Thank you so much, Tom. Now I'd like to turn over to you, Julie, on a question related to the comments made by Tom. If defense counsel has concerned that their child client statements were not given voluntarily or constituted a false confession, what can they do to keep the court from relying on those statements?
Thank you, Emerson and Tom. Those comments that you made, Tom, are so important. To hear a prosecutor recognize that reconciliation, restorative justice, and reintegration are a form of accountability, and that it's not just about incarceration and punishment. Very inspiring. Thank you. And on that point, to answer Emerson's question as to how to address a confession that may be false, this is where it's very important to understand your child's adolescent development stage. Would they have understood what they were saying? Would they have understood they had a choice about whether to answer the questions? Were there things that they said that weren't true because they were trying to take the blame off someone else? For example, did they know it was their big brother or their father who committed this act in a different type of scenario? And are they trying to take the blame so that they don't lose their father? There are so many reasons why a child might falsely confess. They're extremely, extremely vulnerable to the techniques of interrogation that really are not designed for children. They're designed for adults. And so some of the things that would make an investigator believe that the child was confessing truly are exactly the things that are really not indicative of credibility and truth, because children are so vulnerable to the techniques. They can be very easily persuaded to agree to things that aren't true, just as someone with an intellectual disability would be so easily led to say what the officer wants to hear. So we have to be so careful about that. And then to challenge that confession in court, to make motions before the adjudicatory body to try to keep that confession from being used against the child, to try to appeal to the prosecutor's sense of justice, that it would not be appropriate to use a confession when there were so many factors that may not make it reliable. So those are the things I would do. I would encourage you to ask for specialized training in how to challenge this type of a statement, how to keep it out of court. I would encourage your governing bodies to allow motions to suppress those types of statements if you don't already have that as part of your legal structure, because it is so important to keep those out. Once a confession is in, whether it's true or false, kind of loses any ground, because everyone assumes that it is true, and the entire case then builds around that confession, including the investigation of the case, the theory of the case the prosecutor will pursue. Everything then centers around that confession. And if it shouldn't have come in at all, it would have been a very, very different case if we could have kept it out.
Thank you, Julie. These principles are really discussed in the note, and I encourage everyone to go and consult the notes, start reading it, and see how you can apply it in your day-to-day work. Thank you, Julie. Our time is up. Now we are going to move to the next panel, and I would like to pass the floor to my colleague, who is a resident fellow here at the IIJ. Sepu Chamna, you have the floor.
Merci, Emerson. Bonsoir à tous.
Thank you, Emerson. Good afternoon, everyone. I am the moderator of the 5th panel of this workshop. That's the 3rd panel of this session today, and we're happy to be here with you. I am resident fellow at IIJ. I've been resident fellow for 1 year now, and I am an academic, so I also offer training and education on human rights. Well, this workshop is a great opportunity for all of us to use the principle of protecting children in justice. We know that we need to guarantee effective justice for children. We know that this is a long-lasting process. We need to reflect upon it on a constant basis in order to guarantee the best practices and to protect the children while guaranteeing justice. Of course, we know that the worries affecting us are the same everywhere in the world, in all regions, in all countries. Yesterday, we started our workshop discussing the general principles of the notes for the practitioners, and today we are going into the details of the notes. And with this 5th panel, we are going to focus on the role of judges. And I'm honored to invite Lady Justice Teresia Mateka, judge at the High Court of Justice. She is very passionate about juvenile justice. She served as head of station in several court stations and as a trainer at the Judiciary Training Institute of Kenya. She set up the first child protection team in 2002 under the Children Act. This team was the precursor of the current children court user committees, and it included the court, the police, the prisons, the probation and aftercare, the Department of Children's Services. She participated in the development of multiple training curricula on child care and supported several IIJ workshops as a speaker. So, Honorable Mateka, the floor is yours.
Let me start by greeting you. Good afternoon, good morning, good evening. I know we are in different time zones. And to thank you for giving me this opportunity to share a little bit of our Kenyan experience. On 20th of November 2019, the Special Task Force on Children Matters, which falls under the National Council on the Administration of Justice, launched the status report on children in the justice system in Kenya. The report confirmed that the child justice system consists of 6 core interlinked agencies: the police, the local authorities, usually represented by the local chief, children's services, prosecution, courts, and here we also have special children courts, corrective services comprising of prisons, probation and aftercare services, all of which are joined together like a chain link. And ideally, they should function seamlessly, efficiently, and effectively in the delivery of services in the administration of justice. However, they don't, as we've heard since yesterday, and children enter the justice system. In our system, we recognize that they do so in different ways, as children in conflict with the law, or what we refer to as child offenders, children in need of care and protection for various reasons, children who are victims of crime, and even as witnesses. While our data shows that we do not have many cases of children involved in terrorism-related offenses, we do recognize that the child who is charged with terrorism-related offenses can fall into all these categories at the same time: child offender, in need of care and protection, victim, and even a witness. And that is one reason why for every child who enters the justice system, a protection and care file is opened to ensure the consideration of the best interests of the child and the safeguarding of the child's welfare. In the trial, the right to a fair hearing encompasses the right to legal counsel, presentation to court within 24 hours of arrest, determination of the child's age where it is in doubt or in dispute, assessment by experts for necessary reports, bail and bond, and to the expeditious determination of the case. Non-custodial measures, including diversion, are encouraged in the first instance. Noting the existing gaps in the system, the task force has proposed practice guidelines on handling children involved in terrorism and radical extremism, and for the adoption of child-centered and human rights-based approaches in development of policies related to rehabilitation of children involved in these cases. Programs for this rehabilitation are not readily available. It's work in progress. Specific programs, rehabilitation programs. We recognize that in matters related to children, a judge or a judicial officer cannot do it alone. Because as you say here at home, haki ya mtoto ni jukumu letu sote pamoja na mtoto. That means that access to justice for children is the duty of each one of us in the system with the participation of the child. We believe in a multi-agency, multi-door approach to justice, as access to justice has been demonstrated to be a door to social transformation. In this regard, the National Council on the Administration of Justice, the Special Task Force on Children Matters, and the Children Court Users Committees forbear a child justice chain link that is visible, appropriate, and accessible to children through the concerted policy reform and delivery of services. The IIJ Juvenile Justice Practitioner Notes for judges and judicial officers will complement not only our child law and the constitutional protections available in our Bill of Rights to every person accused of committing an offense, but also to our training curriculum. The notes will provide a one-stop shop for judges and judicial officers handling these matters as they synthesize all these requirements into an easy-to-read reference material. These notes, due to their universal application, once launched, will form part of the daily reference materials within the system, not just on terrorism-related cases, but I'm sure in all child-related matters. I wish to take this opportunity to congratulate IIJ Justice Initiative for this and the other notes for the practitioners. Thank you very much.
Alors, merci, Honorable Mateka, de nous avoir présenté votre dispositif juridictionnel au Guinée. Je note et souligne que ce système s'organise autour d'une coordination efficace des services concernés, clé de voûte essentielle pour une prise en charge respectueuse des droits de l'enfant. Vous dites que vous avez peu d'enfants associés à l'extrémisme violent et au terrorisme, mais le Kenya, comme nous tous ici réunis, prend en compte cette spécificité. Vous le faites au Kenya en ouvrant systématiquement un dossier de protection pour le mineur afin de garantir la prise en charge, la prise en compte et la sauvegarde de son bien-être. Ensuite, en assurant tout au long de la procédure le respect des droits de la défense du mineur, quelle que soit sa situation, en encourageant enfin la déjudiciarisation du mineur. En parlant du guide de l'IIJ comme d'un guichet unique pour les juges auxiliaires de justice et auxiliaires de justice en charge de ces questions,
talk about all those things, you have perfectly summed up the importance of the notes concerning a training program. And I really liked and appreciated what you said at the end of your speech, because thanks to these notes from IIJ, you will have the possibility to better fight against terrorism and all the other aspects, including children, in order to better protect them. So thank you very much for your wonderful presentation. And I also welcome the second panelist, the second speaker for this panel. That is to say, Peter Eisma, presiding judge of the Regional Trial Court of the Philippines. He was admitted to the Philippines bar in 1986 and has practiced law as a member of the Public Attorney's Office for more than 5 years. He served as city prosecutor for Isabela City and Zamboanga City for about 11 years. Judge Eisma is also a law professor at 2 universities in the Philippines, teaching different subjects, such as criminal law and special proceedings. You now have the floor.
Thank you. It's night time here in the Philippines, so good morning to you, good evening, and good afternoon. So to start with, in the Philippines, the establishment of family courts in every city and province is mandated and guided by the provisions of the Family Courts Act of 1997, which mandates that a family court has exclusive regional jurisdiction to hear and decide cases involving children who were accused or victims at the time of the commission of the crime. And in relation to the above law, another law was enacted, which is the Juvenile Justice and Welfare Act, which is a system rather dealing with children at risk and children in conflict with the law, and which provides child-appropriate proceedings. And this law made the use of the word child, who is a person under the age of 18 years, while a child at risk refers to a child who is vulnerable to and at the risk of committing criminal offenses because of personal, family, and social circumstances. And the child in conflict with the law, who is alleged as accused of or adjudged as having committed an offense under the Philippine laws. An offense refers to any act or omission which, whether punishable under special penal laws, revised penal code as amended, thus, which includes terrorism and other related offenses. Now, the important and significant provision of this law is that children below 15 years of age or at the time of the commission of the offense shall be exempt from criminal liability. But however, this child shall be subjected to an intervention program. And second, a child above 15 years of age but below 18 years of age shall likewise be exempt from criminal liability and be subjected to an intervention program unless he or she has acted with discernment, in which case such child shall be subjected to the appropriate proceedings in accordance with the law. The exemption of criminal liability does not mean he is exempted from civil liability, and which shall be enforced in accordance with existing laws. In all cases, courts should ensure that children benefit from legal assistance throughout all stages of the proceedings. Early access to legal representation will also reduce the risk that the child may unwittingly waive important rights, such as the right to self-incrimination. So, a judge should carefully assess information about the age of the child suspected or accused of a terrorism offense. He should make independent assessment of all available information before the proceedings would start on that basis. Judges should stay informed about the advanced medical and forensic tests that can be performed to determine age if more traditional information, including birth or baptismal certificates or school, medical, or church records are unavailable. In addition, you should order the state social workers to examine the children accused of offenses and submit a report to the court. Most judges should recognize that children are frequently victims of adults who coerce or forcibly radicalize them and use them to carry out terrorist activities. As a result, it is important that judges ascertain whether children appearing before them acted with discernment. Judicial officials take all possible steps to prevent disclosure to the public or the media of personal or other private information regarding the CICL in judicial proceedings. They should shield children from intense media scrutiny and ensure that their privacy and rights are preserved. Consideration should be given to imposing special security measures during judicial proceedings, such as closed hearings, limited media access and coverage of events in the courtroom, and excluding communication and recording devices such as audio and video recording devices, cell phones, electronic tablets, and similar equipment from the courtroom. And the same law mandates that information concerning children gathered from the time of their initial contacts with authorities until final disposition of their cases is to be considered privileged and confidential. Parties and participants in the proceeding are prohibited from disclosing information about them. And the police must use a separate police blotter encoding system to conceal material information that could lead to the identity of the child's suspects and witnesses. Because prosecutors are members of the diversion committees established under court rule in case diversion is conducted in the courtroom. Because the diversion committees are led by court personnel, the prosecutor, the defense attorney, and assigned social workers together with the complainants and the child accused. The purpose of this committee is to determine if children being charged with crimes can be diverted to receive alternative measures and services. Now, in determination of discernment, the social worker will come up with an initial assessment, which is without prejudice to the preparation of a more comprehensive case study report using the discernment assessment tools developed by the Department of Social Welfare and Development. And if you ask the question, how will a judge in a family court, which is where I'm sitting, will promote the best interest in handling CICL cases? Through diversion process, of course, which is one of the main features of the juvenile justice law. And what is diversion? Diversion refers to an alternative child-appropriate process of determining the responsibility and treatment of a child in conflict with the law on the basis of his or her social, cultural, economic, psychological, or educational background without resorting to formal court proceedings. And the diversion program, which will be formulated, refers to the program that the child in conflict with the law is required to undergo after he or she is found responsible for an offense without, of course, resorting to formal court proceedings. Okay? So, as a final note, instead of punishing juvenile offenders and treating them as criminals, these child offenders will be provided by the state and community with assistance to prevent them from committing future offenses. The juvenile justice law in the Philippines intends to deal with these children without resorting to judicial proceedings. Thank you for this opportunity.
Merci.
Thank you very much.
Monsieur Peter Esma,
Thank you very much,
pour votre
Mr.
riche et pertinente
Aisma, for
intervention
your
qui nous dresse vraiment le
intervention
processus de traitement des
that
appels terroristes
has
impliquant les mineurs
explained
philippins.
actually how
Donc,
the
si votre système s'adapte aux
how
fonctions
children
en fonction de l'âge
are
de l'enfant,
considered
il se
within
fonde
the
sur deux points
legal
cruciaux:
process in the
le respect de
Philippines.
sa vie privée et ce,
I
quel
have
que soit son âge et
really
son profil,
appreciated the two aspects that
et
you have
l'assistance
underlined in your
obligatoire
presentation,
par
that is
un
to say
avocat, quelle
the
que soit la situation
respect
financière de ses
of
parents.
privacy of the
Nous avons
children,
bien saisi
and also the fact
que
that
la
the
réponse
family
pénale
needs to be
se
supported
fonde sur la
as well.
détermination de l'âge de
I
l'enfant.
have
C'est-à-dire
understood
que
that
l'enfant
everything
âgé
is
de moins de
based
15 ans
on
est
the
irresponsable
age
pénalement
of
et doit être remis
the
à ses parents ou, à
child.
défaut,
So if
être
the
pris en charge par
child
des structures spécialisées.
is
L'enfant entre 15 et
under
18 ans
18
qui a
years
agi
old,
sans
then
discernement
the family needs to
peut être
take
libéré
care
et placé
of the
dans un
children,
établissement de protection
and
d'enfance.
there is also the
Et enfin,
possibility to
l'enfant
place the
entre 15
child
et 18 ans qui a
within a
grandi avec
center for the
discernement
protection
doit
of the
bénéficier
child
d'un programme de
itself. And of
déjudiciarisation.
course, we needed to
Si
take
les
into
volontaires
consideration the
qui
usage
s'intéressera
of a
puissent être
diversion
considérés comme une
system or
preuve de culpabilité.
program in order
Ce
to
processus
take
est
better
précis et
care
suppose la
of the
collaboration de toutes les
child.
parties prenantes
This
sous la
system
supervision du
is
juge.
approved and works very
Je vous
well, and
remercie
of course
beaucoup
needs a
de cette
complete
intervention qui
collaboration of all
s'inscrit
the
dans la
different
droite ligne
actors
du
involved
guide de
in
l'IIJ.
this field, and in
À présent, je
particular
pense
of
que
involved
nous
in
avons
the
très peu de temps, mais
process.
nous allons quand même passer
I
à
also thank you
quelques
for the
questions.
collaboration in
Et
order
la première
to
question que je vais retourner
create
à
these
l'honorable juge
notes of
Mateka.
the IIJ. So
Et dans le
we,
cadre
IIJ,
d'une
we
infraction
have
terroriste,
some
vous
questions.
recevez au
First of
tribunal un
all,
enfant qui a
for
été interrogé par
Madame
la police et a
Mateka,
fait des déclarations sans la présence
that is to
d'un conseil.
say, which
Lesquelles
declarations
déclarations ont permis
allowed
de
to
recueillir des éléments
collect
de preuve
some elements in order
Quelle
to
appréciation
understand
faites-vous
if
des
a child
déclarations
is
et éléments de preuve recueillis? Comment allez-vous
needs to
procéder
take
pour
be
assurer
into the
le
responsibility,
respect du
and
droit de
how do
l'enfant?
you normally go on with this
À vous la
process
parole,
in your
honorable.
country in order to understand if a child is responsible of a crime or not? And you have the floor now.
Thank you very much, Mr. Sumner. One of the things that we are very alive to in the courts is that in our constitution, we have Article 49 that protects the rights of arrested persons. any person who is arrested has a certain rights, and these rights apply to children as well. And therefore, whatever police do with a child, whether it's a child arrested for terrorism or for any other offense, the same rights apply. So we do not differentiate that this child is charged with terrorism or this child is charged with a different offense. We also have our child offender rules, which are under the Children's Act, that really set out that when a child is arrested, the police officer in charge of the station where that child is taken is under obligation, legal duty, to inform the parent. If they cannot find a parent, a guardian, or an advocate appointed for the child. If that is not available, they can inform the children's officer or any of the other authorized officers under the Children's Act to be present during the interview. Even our legal aid law actually makes it mandatory for any officer in charge of a police station or a holding facility for children to inform that child of their right. So therefore, one of the rights is the right to remain silent. They are required to inform the child. You do not have to say anything, because anything you say can be used against you. So the right to remain silent is a right that is also available to children. So when a police officer interviews a child without an advocate or without complying to the law, with the law or the constitutional provisions, then that police officer is acting in violation of the rights of that child. And what that means is that that statement that is obtained from that child can be challenged as a statement obtained in violation of the constitutional rights of that child. And upon challenge, it may be rejected if it is found for sure that it was obtained contrary to the provisions of our Constitution. Now, what do we do to protect the rights of that child? Of course, the first protection is if the statement was obtained contrary to the protections that are available to this child about making statements or confessions, then the court is under obligation upon challenge of that statement to reject it. It cannot be used against that child if the statement was taken against the provisions of the law, without a lawyer. And then, of course, that evidence obtained from the child, if it is against certain people, then those people also have the opportunity to challenge that evidence. If it was obtained contrary to the law, then the same people who are, maybe the police would want to use the evidence against them, have a right to challenge that evidence. So two things: the statement cannot be used against the child if it was obtained contrary to the law. Thank you very much. Back to you, Mr. Sumner.
Merci beaucoup, honorable Mateka.
Thank you very much.
Beaucoup de questions pour vous.
Actually, we have several questions for you, thanks to your great experience in Kenya, but I have to ask another question to Mr. Peter Aisma in order to ask him another question. So without documents attesting and assessing the age of the children, how can you determine his or her age and therefore how to go on with the procedure according to the specific law?
Well, what we do here with in case no documents are available to in the determination of the age of the child, first a social case study is conducted. A social worker would go through the motions of conducting a study and make a report to the judge, and the judge usually orders the child to be examined by a dentist, which more or less could determine whether or not the child is above 18 or below 18. Well, I think it's because of that, what we call the wisdom tooth, which appears before the age of 25. That's the essence of the determination of the age, whether a child is a minor or not. That's basically what we do here. Thank you.
Merci beaucoup,
Thank you very much
Je vais
for
peut-être,
this answer.
me retourner vers l'honorable Mateka.
And now I'm going
pour
back
la
for
deuxième
another
question.
question to Ms.
Je
Mateka.
voudrais savoir quelle
I
est
would
la
like to
place
know
de la
which
communauté
is
d'origine
the
du
place
mineur
of the
associé au
community of
terrorisme
origin of a
ou à
child when
l'extrémisme
he is
violent qui
associated
admet
to
un programme de
terrorism
relaxation au Kenya. Je pense que je
in
vais
Kenya.
retourner la même
And
question après
I will
au
ask
juge
exactly
Esma,
the
si
same
on a le
question
temps.
to Mr.
Mais
Peter
déjà,
Esma
on peut
later
vous
on
écouter,
if we will
honorable
have
Mateka.
some time. But first of all, the floor is yours, Ms. Mateka.
Thank you very much, Mr. Sumner, for that question. One of the things that we believe here, and actually it's the fact, that when a child commits a crime or is in conflict with the law, they do it in the community. So it starts there from the community. And when they go through the whole justice system, they have to come back to the community. So the system begins from the community and ends back in the community. So the community has both is accountable for the child's conduct and behavior, and also for enabling the child to fit back into the community. Actually, we say that for a child to commit an offense, there is a break in the chain link that is supposed to hold this child. As you may be aware of this thing, that it takes a whole village or community to raise a child. The same one will need to be available to rehabilitate this child. So what is the importance? One, that within that community, it is where the family is. It is where the offense happened. It is where the victim is. And it's also where the solution to what led the child to commit the offense is. So when we are making orders, either in court for reintegration of children or for rehabilitation in the community, then we must get a social inquiry report, either from the Department of Children's Services or probation and aftercare, to find out for us as the court what is the best way to deal with the child within the community. If the community is willing, readily willing to take the child back, there's usually no problem. Where there is a challenge about either stigma and all the related issues, then the social worker has to work with that community and with the family to see how the child gets back. So the community actually is at the center of everything about the, and talking about community means exactly the family, the significant others, and the wider community that could be either the estate where the child lives or the village where the child lives. That is you know, when we talk about community, that's what it is. So they are important in providing the programs for rehabilitation. What is available? If the child has to go back to school, what kind of psychosocial support will be available in that school, within that community? If the child requires psychosocial support, who is going to give it within the community? Because it has to be somebody or people who are respected, who can be role models, who can be able to do this. If the child is going to need a mentor or people to mentor this, they have to come from the same community. So it's very important for this child to be able to be reintegrated back in the community where they came from. If it is difficult for whatever reason, then the social worker will give a recommendation as to the other place where the child can be taken. But the most important place for the child is within the community. And I want to be specific again that we do not categorize the child as child has committed terrorism or child has committed this other offense. It is a child who is in conflict with the law, and the standards are the same. But of course, the community has a bigger negative attitude towards certain offenses committed by anyone, including children. But again, as I said, the court will go with the recommendations that are made, and it will make inquiries to see what is best for the child within that community. Thank you very much.
Thank you so much, Samna, and thank you to our panelists, all of them, for those fascinating interventions and answers to questions. One thing that has become clear throughout the last 2 days of presentations and questions is that the challenge of protecting children's rights is universal, The interest in improving our collective approach is great, and the need for clear guidance on how to do so is compelling. Along with other guides and toolkits that many of our presenters have mentioned in their remarks, we're very optimistic that the practitioner's notes we inaugurate today and that we talked about yesterday will become a foundational document that will offer just this type of guidance and become an invaluable tool for practitioners in their work with children. The impact of these notes, however, will depend on three things: distribution, comprehension, and implementation. Please allow me to address each in turn. First, we, the IIJ team, and all of you need to make sure that these notes get into the hands of the practitioners who need them. For those of you who have not yet reviewed the notes, please visit the IIJ website where you can access a copy in English, French, or Arabic. Once you have read and appreciated the notes, please share them widely. If you want paper copies for your agency, please let us know. The more practitioners have access to these notes, the greater the impact they will have. Second, practitioners need to understand how best to use the practitioner's notes in their daily work. On this, the IIJ is planning an ambitious program over the coming weeks and months to roll out these notes through a series of roundtables and workshops. We will be reaching out to many of you to make this happen, but we need your support. If you, your agency, or your country would benefit from training and would like us to include you in one of these programs, please let us know. If you or your agency would be interested in hosting one of these programs along with the IIJ, please reach out. If you're interested in working with us, or in many of your cases, continuing to work with us as an expert or consultant, please reach out and let us know. If you've identified any unmet needs that the guides don't address or that we haven't discussed in this launch over the last 2 days, reach out and share that with us. And by all means, for all of you who posed very interesting questions in the Q&A feature of this platform that we unfortunately did not have time to answer today, share them with us, and we'll either answer you directly or make sure that we cover those topics in our programs in the coming weeks and months. We will be providing the link for our website at the end of these remarks and other information by which you can contact us. And finally, no guiding document, no matter how well conceived or written, can have impact unless it is implemented. We therefore encourage all of you to use these notes to inform your practice going forward and to model the principles they contain. Half the battle in improving respect for children's rights is understanding how important it is and in striving to do better. Respecting children's rights in the context of terrorism cases, it's become clear over the last 2 days, it was clear to many of us before, is highly complex, nuanced, requires training and resources, and can be just plain hard. None of us holds all the answers, nor do we have the power ourselves to overcome all the challenges. But we all have the power to inform ourselves, to identify areas of improvement, and to take the first steps toward meeting them. And we're hopeful that these practitioners' notes will accompany each of you in that journey. We also hope these notes will create a framework for a common approach that improves all of our treatment of children involved in terrorism cases. With that, on behalf of the entire team here at the IIJ, I wish to again express my thanks to all of our speakers for their timely and thoughtful presentations and their answers to the questions we had time to pose. Also to the U.S. Department of State Bureau of Counterterrorism for its support of our work on juvenile justice and for its sponsorship of this event. And finally, to all of you who took time out of your busy schedules to participate from all corners of the world, and for sharing your interest in improving the treatment of children involved in terrorism cases. Please follow the IIJ website and our social media feeds for news on upcoming events and additional publications on this and other subjects of global interest to criminal justice practitioners. And finally, please stay in touch. We very much appreciate your partnership. Thank you very much and enjoy the rest of your morning, day, or evening, as the case may be. Goodbye.